Who is for petitioner? Who is for petitioner?
Yes.
We are disposing of the matter today.
We file reply in every.
What reply?
Yes, sir.
What is the status?
Work is already going on.
Percentage of what? Completion?
Maybe since the petition also come very late. So before that work
So
is
maybe 60, more than 60%.
maybe latest status I have no idea.
When do you want?
On 2nd of December, Your Lordship.
Oh. The petitioner they are trying to fix on 20th December
22 December.
20.
Fix that number, 27.
Can it be on 20th December?
20.
Yes, sir. 20.
20.
December, yes, sir. No.
On the joint prayer of land council for the parties, list this matter. These matters. No, it should be separate order, I think. Same order, but separate order.
Almost similar matter.
Same order, but separately. Let this matter be listed on 2012-2020.
What of life, Your Lordship?
May I please, Your Lordship?
Yes.
Lordship, I beg to mention unlisted matter for today, Lordship.
What is the urgency?
Lordship, it is a transfer posting matter.
Tomorrow.
Lordship, tomorrow I have, Lordship, can it be today as a last item, Lordship? Last item as a last item.
Why not tomorrow?
Lordship, I have some personal difficulty, Lordship. I mean, regarding health, Lordship. Deeply obliged.
If I may, my lord.
Yes.
My lord, I beg to mention two pending matters, my lord. I beg to mention for listing of two pending matters, my lord.
After 2 weeks.
Actually, lordship,
What is the urgency?
lordship, these two anticipated bails were referred, filed under the old CRPC, and the matter was referred to the
Next week.
that's why, on 27th next week, lordship. Much appreciated.
My friend, please, Lordship. Lordship, I beg to mention one unlisted matter. One unlisted matter.
Is there any urgency?
Yes, urgency. About it is regarding about tender.
Tender.
Yes, Lordship.
Tender is no urgency.
Urgency is there, Lordship. Kindly.
What we can do?
Well, please, Lordship. Lordship, I beg to mention item number 20. Item number 20. Sir.
20.
Yes, sir.
What do you
Lordship, conducting counsel came over. He could not appear today because due to some personal difficulties, Lordship.
On the prayer of Mr. G. Tai, Land Council appearing. G. Tai, Land Council for the petitioner. And petitioner. No. Mr. G. Tai, Land Council for the petitioner submits that leading counsel Mr. K. Bogo is indisposed. Mr. Therefore, request for
Matter may be
adjournment of the matter.
fixed 26.
Adjournment of the matter after 2 weeks.
Lordship, fix the.
This was fixed. You see the record last week. I mean, Monday it was fixed for today.
Yes, Lord.
Let us see. It was listed last Monday or?
Yes.
It was
Yes,
not-
after
not-
4 weeks. After last time it was.
It was listed this last Monday.
No, it's on April. Thereafter, there was no record.
They are listed on 18. And on your mention, this has been listed again today. You are seeking and fixed date again on 26.
Yes, Lordship.
Is it a joke?
No, sir, Lordship. Lordship, I have been instructed by my senior.
Sir, it was listed on 18. Today is what? Look at this. It was listed on 18. On your prayer, it again listed today.
Sorry, Lordship, I have no idea. I have been instructed by my
You,
senior.
I mean, lawyers may not be interested in taking up the matter, but this court, once it is listed, we go through the briefs whole night. If it's not completed, we get up at 5 o'clock and look at the file. So every week, every day, in 1 week, if you get it listed, again wants to fix after a few days. What more kind of after 2 weeks?
Okay. Lordship, there is interim order. That will continue. There is interim order.
Whole problem is there. That is the whole problem. Are you in this matter?
No,
Have you gone through the brief?
no, Lordship.
Then? Anyway, be careful next time.
Deep village.
Okay, on 18, some Mr. Ado had appeared. On 26, even if you fix it, some other lawyer will again appear and seeking for adjournment for 1 week and fixed date after a week. This matter was listed on 18/11/2024. And on the prayer of Mr. D. the learned counsel, matter was listed today. However, Mr. Jita today appearing for the petitioner, again sought for a time by praying for fixing the matter on 26/11/2024. Mr. Next paragraph. Considering the repeated adjournment for few days and seeking for the praying for fixing the matter again, this court expresses its displeasure. Mr. However, considering that the leading counsel, Mr. K. Pogo, is indisposed, let this matter be listed after 2 weeks. 2 weeks. Have relaxed and come.
May I please, Your Lordship?
Yes.
I would like to mention item number 17. On behalf of leading counsel Subu Koyang, some personal difficulties. He is not present in the station, out of the stations. And respondent number 3, he represents.
We have heard this matter for so many occasions. On so many occasions, we have heard this matter. What remains there? What is this? Where is Mr. Kamdu?
Already took the concern.
What consent?
Leading counsel, the Kamdu.
Then both the leading counsel and the respond, you decide what order should be passed. We will just sign it. You decide and come. You dictate the order and come. We'll just simply put our signature. Where is Mr. Kamduk?
No idea regarding. Only the telephonically I took the concern, and Koyang sir also took the concern.
So you are not concerned about whether the court will agree it or not. Whether these briefs are being placed in the residence of the judges. And it's of 2018 matter. This court has heard it on so many occasions. Or are you not interested to argue the matter before this court? Tell us.
Your Honor,
List
I
it for
conveyed,
before other bench.
I conveyed the leading counsel Subu Koyang sir. Only I instructed to take the adjournment, Your Honor.
You tell.
May I please, Your Lordship? Your Lordship,
Tell Mr. Kamduk also. Inform Mr. Kamduk also.
Your Lordship, I'm appearing for respondent number 1 and 2
Yes.
for state respondent. And Mr. Subu Koyan, sir, he is for private respondent. Your Lordship. I think he is not keeping well, Your Lordship. I heard it.
Seriously.
Yes, Your Lordship.
We'll see. We'll see. Inform Mr. Kamduk also. If you are not interested to argue the matter before this bench, before this court, we'll fix it before any other appropriate bench, not before this bench. We'll see. Yes, next.
Your Lordship, I beg to mention one unlisted matter.
Where's the urgency?
Your Lordship, the urgency is that the land in question will be surveyed on Tuesday, and Monday being holiday. The land in question will be surveyed on Tuesday for the
Land in.
land in question, I mean, the subject matter of the petition. The land in question, the subject matter of the petition will be surveyed on Tuesday for the construction of a project. But someone else is holding an LPC over that land which belongs to the petitioner. Hence this petition, Your Lordship.
So
Monday is the holiday, Your Lordship.
you'll be evicted on Monday.
No, Your Lordship.
It's an eviction matter.
No.
What is it?
It's the illegal possession of LPC over land that belongs to someone else.
Possession of LPC.
Yes, Your Lordship.
Issuance of LPC against your land, against you.
Yes, Your Lordship.
So we'll take it up on Tuesday.
Your Lordship, the land will be surveyed for a project on Tuesday.
It's okay. What project?
It's a multi-purpose project.
Multi-purpose project is good. You don't want any development. You don't want that any infrastructure should be created by the state.
Your Lordship, the concern is that the land belongs to the
What kind
petition.
of project?
It's debunked multi-purpose project, Your Lordship.
We'll see. Allowed, we'll see. But we're not sure. What must Titapa, London Council for the accused applicant. This is an application under section
Under VNS.
528. 528,
No, 430.
438, VNSS,
VNS.
praying for privilege of pre-arrest bail of the accused person, Mr. Sri Dheeraj Pao, in connection with ROPS case number. What is the number?
63 of 2024.
63 of 2024. Under section 318,
318. Under block 3184. Slash
318 within bracket 4.
within bracket 4. And
3 within bracket 5 of BNS 2023. Call for the case diary. Mr. G. Thado, learned additional PP, enters appearance and executive notice on behalf of the state. Next para. List it on
26.
28. You are already in jail.
Interim order is
It's-
also there. Interim order. It was
See, you are already in jail, so in some other connected matter.
station wise, I am producing that is why.
It's okay.
Case of my
That's why
arrest,
we'll
will
see.
be processed.
What?
Case of my arrest in the Alopias.
You are already in jail in some other case.
Another. Not
Yes.
in Alopias.
Unless you,
That is why.
if the police, see,
Short date may be fixed. Otherwise.
you are still in the custody in the
Yes,
jail
custody.
in some other case.
Yes.
Unless the production and some other the formalities are done, you will not be arrested by the Alo police. They
No.
cannot.
They will, their requisition, requisitioning is going on from one police station to another. That is. I will call.
So that's why I'm saying, unless that is done, you will not be arrested. Requisition is something different.
That is why.
They may not arrest you also.
It is 21.
28. 28.
Interim-
Otherwise, I'm not averse to provide, grant you an interim bail. It's of no use. You are already in
There is a very meritorious case. Interim order may be granted.
I have objection
what objection?
for.
It's a civil. You are trying to put it in a criminal color. It's a civil dispute, contract matter
No,
in the interim.
it's in corresponding
In the
section.
event of arrest of the accused person, namely Sri Dheeraj Pao, he shall be released on interim pre-arrest bail on furnishing a bail bond of rupees 25,000 with no, make it 30,000. 30,000 with with one surety of like amount to the satisfaction of the arresting authority on the following conditions. You just say, shall cooperate with the investigating officer and shall not that evidence and all, receive from the witnesses and all. 2 conditions.
Your Lordship, both criminal and civil can go hand in hand. It can parallel litigation can be.
Sir,
It was duping. It was charged against 420 in earlier act.
We'll see on 28.
Obligation. Little correction, Your Lordship. Application is under 482 of BNSS.
Yes, 480. BNS is 23.
Obligation.
About cancelling the impugn order issued by the Deputy Commissioner Likawali. Wherever my lord, he is making an attempt to try a land dispute case.
Appeal against the Keba is lies whom? Where?
Civil judge, senior division.
Civil division.
Yes.
Civil judge.
Yes.
Senior division.
Senior division.
Yes.
Yes, Your Lordship. Notice may be issued, Your Lordship.
Will state is heard Mr. G. Riva, learned counsel for the petitioners.
Yes.
Petitioner.
Petitioner.
Petitioner. Next para. By filing this application. No, not filing this. challenge made in this writ petition is to the order public notice dated 18/11/2024 issued by the respondent number 3. Who is respondent number 3?
ESC.
Extra Assistant Commissioner. On behalf of the respondent number 2, the Deputy Commissioner, West, the Lower Siang Liquor Valley. Where is that? Where is the notice?
23, my lord.
20?
3.
No, no, will not say. This is something, this is communication. Order dated, to 18/11/2024 issued by the Deputy Commissioner, respondent number 2. No, as directed by, sorry, just keep it. Issued by the ESC for Deputy Commissioner, Lower Siang District Liquor Valley, whereby head Gaburas and Gaburas. Have you been directed to appear?
Yes,
Where it is? Where's your name?
there is on serial number 5
Serial number 5.
below.
The copy is for the petitioner, your
Okay.
lordship, not to the notice has not been served to the
Whereby
petitioner.
head Gaburas and public leaders of CG village have been directed to attend the office of the Deputy Commissioner on 22/11/2024 to discuss the matter of land dispute between Srimati, the respondent number one Srimati Tumken Riba and Sri Singho Taiblude, as well as the petitioner. No, it's something like,
No, my lord.
it's
It is-
not a discussion, it's only for discussion.
There is also, my lord, per se illegal, my lord. But my lord will find this Akaba decision at page number 13. my lord.
I told they have filed an appeal against the land dispute.
It is an appeal. It is an appeal. my lord. It has been taken up as an appeal. my lord.
Where it is?
My lord,
It doesn't say anything.
my lord will find a Akaba decision at page number 13. my lord. Challenging these, my lord, they have approached the London DC.
A copy of which has also been directed, furnished to the petitioner. Mr. Next paragraph. It is the contention of the petitioner that the land disputes, the present land dispute sought to be discussed by the Deputy Commissioner by the authorities by inviting the head GBs, head Gaburas and public leaders of CG village have already been decided by the village authority. Mr. The as per the applicable provisions of law, if any party is aggrieved by the decision of the village authority, an appeal lies to the Court of Civil Judge Senior Division.
Yes.
Therefore, the disputes which have been settled by the village authority cannot be taken up by the deputy commissioner as the executive authority, like the deputy commissioner and assistant commissioner doesn't have the, no longer have any jurisdiction to decide the land dispute. Next. Issue notice to the respondents returnable by 3 weeks. MS Arbasat and State Council appears for
1, 2, and 3.
entered appearance and accepted notice on behalf of respondent number 1, 2, and 3. Mr. And then next paragraph. Petitioners to take it for service of notice upon the respondent number 4 and 5. Registered for so and so and so. Next paragraph. In the interim. No, next paragraph. Heard on the interim prayer. Next paragraph. Considering that the considering that admittedly considering that the deputy commissioner of the assistant extra assistant commissioner no longer having a jurisdiction in respect of the civil disputes on the coming into force of the Arunachal Pradesh Civil Courts Amendment, Civil Courts Act 2021, and the further and the amendment thereafter. Come on. In the interim, the impure order dated 18/11/2024 issued by the Assistant Extra Assistant Commissioner for Deputy Commercial Lawyers shall remain suspended. List after 3 weeks.
Extra copies.
Extra, just say extra copies.
Okay.
Formal notice need be served and our extra copy. What can we do? We'll just issue notice, we'll see. It's already conducted, exam already conducted. We in between we cannot stall. We'll see.
Also,
If the writ petition allowed, we may set as that entire proceedings. But at this stage, we cannot do anything. When is the next exam? I mean, Viva.
Viva is on Lordship Monday, Tuesday, Lordship, 25 and notice. That is the
You
problem.
cannot stall because you have not been. You, in fact, you have, you should have come earlier.
Actually, Lordship, only issue.
In that case, we could have privacy if you could establish, we could have direct you to appear in the written exam. Now written exam is over. Viva, I think it would not be appropriate to interpret it.
Lordship, only.
Well, definitely will issue notice.
Lordship,
You
Viva
just, Viva we cannot risk. Because already wrongly or rightly written exam, they will be deprived. Other candidate will be deprived.
actually, only
For no fault of them.
Lordship, only issue was only that there should be.
Yes, whether
Yes.
your qualification can be, whether you are eligible as
Yes.
per your
Yes,
qualification.
Lordship.
Life science,
Biotechnology.
MSc in biotechnology.
Yes,
According to you, MSc in biotechnology is a life science.
yes, life science. Lord.
That is, we'll
Yes.
have to hear it. They are saying that it's not life science. Are they saying? Are they saying that it's not a life science?
Yeah, they are saying that it is not a life science.
So we'll see. Let
That
them,
is the-
we'll take the, I mean,
Now,
Let us see their response. We'll issue notice. Or Mr. T. Topu, learned counsel for the petitioner. Challenge made in this writ petition is to the rejection of the candidature of petitioner on the ground that the education qualification of the education qualification, i.e., that is MSc in biotechnology,
yes,
does not fall under the subject by life science. Please stop. The petitioner has also prayed for acceptance of his candidature and to reconduct the recruitment test for the post of lecturer within bracket DIET pursuant to the advertisement. What is the advertisement?
advertisement, lordship, page number 27. Annexure 4.
That is 16/08/2024 issued by the issued by whom?
Issued by lordship, Joint Secretary, Control of Examinations.
The Arunachal Pradesh Public Service Commission. Issue notice returnable by 4 weeks. Mr. All are represented.
My lord, yes,
Mr. London Senior Counsel and Standing Counsel for Standing Counsel enters appearance in on behalf of
3 and 4.
respondent number 2 also
3 and 4. Yes.
2, 3, and 4. No formal notice need be served. However, extra copy. No need to be. Mr. Waidiram, State Council, the Assistant Council for respondent number 1, and Mr. Titaba, Learned Council for the respondent number 5. Therefore, no formal notice need be served. However, extra copies be furnished to the Learned Council for the response. That's all. List after 4 weeks.
Declare.
Are you convinced, Mr. Topu, that we cannot pass an interim order?
All right,
You have come late. You have come late.
I do agree.
That objection is not ready. Not affidavit, objection. We have filed this morning.
Yes. After some time, no, sir.
Now, my Samsung hearing the case is there.
We have called for the affidavit filed by the respondent. It is,
I receive now in the court.
no, it's not ready.
I receive now in the court. But they
Now
they can enter.
Registry, it is not complete. The process has not been completed. It's not been placed with the record. So we'll take it after some time.
May I please?
We'll admit.
Yes.
It has not been admitted.
Not it. Condonation was.
And your, this thing, suspension of sentence will be heard next. All right. Heard Mr. J. Siri, London Council for the appellant. And appeal under section 415 within bracket 2 bracket close of BNSS 2023. Against the judgment and order that is 2708/2024 passed by the special judge NDPS formed in NDPS case number 13 of 2023, whereby the appellant has been convicted and sentenced, convicted and sentenced to undergo rigorous imprisonment for 10 years and with a fine of rupees 1 lakh with a stipulation to further undergo 3 months of imprisonment. Admit, call for the records. Mr. G. Tadon additional copy appears for the state. In IA, huh? Heard so and so, so and so. This is the application so and so, so and so. For this is bail or
For suspension of
suspension
sentence.
of sentence, so and so, so and so. Issue notice, huh? Mr. C. Tadon appears for the state, huh? Return
Observation that my lord, on the next day, the
obviously.
Suspension.
Notice is- he has already. You have any objection?
Yes.
Suspension of sentence.
Yes.
You file an objection. If any. List after
2 weeks.
list after 2 weeks.
yes.
List after 2 weeks.
Trial court report may be called for. Trial court report.
We have called in that thing.
Oh. Then,
In that case, 3 weeks.
then meantime, paperwork may be also directed to prepare paperwork.
When until the records come, how can we direct?
Oh, I thought LCL also already received.
Have you gone through?
No,
This,
that's why,
this appeal is listed for the first time.
that's how I pray for calling of LCL.
Understood? List after 3 weeks. Huh? Issue notice, list after 3 weeks. In the meantime, the learned additional PP, Mr. G. Tadon may file objection, if any.
Obliger.
Wait, please, your lordship.
It's one by one or together at a time?
One by one will be better.
Why?
Uh,
Why
only,
so many writ petitions?
now,
It's
there are
out of same one
Issue is same, my lord.
one
Whether
sentence.
issue is same.
issue is same.
Different petitioners.
Yes.
Different petitioners.
But are you representing all of them?
No, no.
Then
I am representing the in item number 6, 7, and 9. I am representing petitioners in 6, 7, and 9.
6, 7, and who is for 8?
Eight, my lord, I am there. Oh. I am there for 8.
Very difficult.
No.
Yes.
Now, in,
Why so many writ petitions?
yes, now I am
For
coming
one
to that.
tender?
I am coming to that.
I understand if there are the different petitioners. Why only one petitioner for different, so many petitions?
That I am coming with. The item number 6, 93 was filed at a time when the tender process had just begun.
Yes.
Nothing was finalized. And the Honorable Court passed looking at the kind of grievance and the plea of arbitrariness that we have taken, Honorable Court passed a direction that tender should not be finalized without leave of the court. They may go ahead with the processing, but they shall not be finalized.
Yes.
Now, after filing of the writ petition, my lord, they issued a corrigendum, further modifying the terms of the tender.
Yes.
So that is why the item number 9 writ petition 227 had to be filed.
Item number 9.
9, yes.
Hmm.
Item number
227.
227 had to be filed challenging the modified terms. Corrigendum. Now, item number 7 is another writ petition by a different party in respect of a different tender, but on exactly identical issues.
Different tender.
Different tender, but exactly identical issues. Only the value of the tender is different.
It's a separate tender.
Separate tender.
By
Separate
the same department.
Same department.
With the same terms and conditions.
Same terms and conditions. Exactly copy paste terms and
So
conditions.
in that case, if this item 6, the terms and conditions which you have put to challenge,
yes,
have been modified, what remains there?
No,
Item 6.
that have not been modified in its entirety. Only
There has been some addition.
yes,
Addition
only part of the terms and conditions have been modified. So therefore, 6 and 9, these are in a sense, my lord, these are exactly connected. Exactly connected. The amendment of the terms and conditions is under challenge in 9, and the 6 is the first, I mean, the NIT as it originally
6
stood.
and 9.
6 and
Okay.
9.
Then
Now,
what about 8?
8 is also of the same tender. 6, 9 and 8, they stand on the same footing.
The same tender.
Same tender.
They are challenging the same terms and conditions.
Same terms and conditions.
Okay. So 6, 7,
6,
6, 8 and 9
yes. 6, 8 and 9 are
can be heard first.
can be heard first. No, Milord, in my submission, I'll, since the volume is, I mean, the 6, 9, the petitions are more voluminous. So, I'll for the,
Why, even if you're voluminous, we'll look into the relevant issue only.
well, if I can show it from your lordship,
Are
the
you-
item, item number 7, Milord, actually, that is how I prepared it. Subject to, of course, your lordship's or permission, Milord. If I can show your lordship to the illegality and arbitrariness in item number
Just
7.
show what the conditions
Yes.
and why this is so arbitrary and illegal.
Yes,
That's
yes,
all.
yes. So if your lordship takes up 7 first, well, things will be clear. Only thing is that 7 and 6 and 9, these are two different tenders, but by the same authority on exactly same terms and conditions.
7.
7.
No issue if it's similar.
Yes. Now,
7, item 7.
yes, item 7. And my lord, along with the item 7.
See, it's a tender method. Make it very simple.
Yes, yes.
Don't make it complicated.
No. It's a,
Otherwise,
my lord,
we understand.
my lord, my
We understand the senior lawyers
no,
and the experienced lawyers.
my lord, I know that my limit is very
This
restricted.
court always tries to be very precious, short,
My
to the-
lord,
to the
my
point.
lord, my lord, since I have challenged the terms and conditions,
Yes.
my primary responsibility is to demonstrate before your lordship that the terms and conditions are arbitrary and illegal. Now, once I discharge that pardon, my lord, then only your lords, subject to your lordship satisfaction, then only your lordship will call for my friend to explain the reasons. So my first emphasis before your lordship will be to demonstrate that the terms and conditions are so arbitrary and it is so restrictive in a sense that only a handful of bidders can participate and others cannot come. It's a restrictive terms and condition in that sense. Now, if your lordship,
So this is for final disposal.
Yes,
I am ready for final disposal, my lord.
my lord, just a clarification, my lord. So for item number 7 is concerned,
Yes.
my lord, 3 bidders they participate. No one qualified. Then the tender committee recommended to the government for fresh NIT and government approved. Very shortly, I think the permit they will be going to float a fresh tender. So partially the item does will become infructuous. That's why you, yes,
No,
item
it
seven,
will-
no,
because-
no, just a minute. Because no one qualified, madam. So tender committee, they have recommended to the government, since no one qualified, then advise the government for fresh tender.
Item 7.
Yes, that has been approved.
Now,
Just a minute. So, my lord, if my friend can start for item number 6, that is the my lord basis starting, my lord.
no,
The
Malad,
terms and
in-
conditions.
In item number
Why
7 also.
Item number 7, my
In
lord.
item number 7, this submission was made by my learned friend on a previous day.
No.
Now, yes, submission to complete करने दो. इतना रोकने से कैसे होगा?
No, see,
Yes, this submission was made by my learned friend on a previous day. The honorable court considered it and passed an interim order. In a sense, your lordship can see it from the records. Honorable court passed an order that till the time there was a grievance pending before the respondent authorities. Well, that order, your lordship will kindly find, it is passed by Honorable Justice UK Nair.
Correct. Item number 7.
which order?
My lord, that will be. Online ना तुम्हें item second copy. Order sheet नहीं था उनपे.
One in 105.
Yes, 105. Your lordship may kindly see the order dated 25th of July 2024. 25th of July 2024.
25th.
25th of July 2024.
Yes.
Then may I read that out to your lordship? Heart so and so, so and so, so and so. Mr. Learned, Additional Advocate General so and so on instruction has submitted that the bids received in pursuance to the notice inviting tender were considered by the tender selection committee, and such consideration being made, it was found that none of the bidders were found to have satisfied the eligibility criteria as mentioned in the said NIT. And accordingly, the tender selection committee had recommended for retender in the matter. The said recommendation of the tender selection committee was accepted by the government. So has further submitted that in that view of the matter, no further adjudication is called for in the present proceeding. Mr. Dotto Learned Senior Counsel, by referring to Annexure B of the notice dated so and so, has submitted that the manner in which the qualification points have been.
Till returnable date. Returnable date is over.
Yes, thereafter it has continued, Miller.
We'll consider it.
No, that's why, Miller, I said that same submission was made. But what the Honorable Court had passed is that.
How can we stop them to have a press tender and all?
No, Miller,
I have a blanket.
No, I am not saying that. I am not saying that they should not go for a tender.
See, similar things are being put to challenge. Maybe a different tender. The point to which you are raising, it's one and the same. Either in the other writ petition or this writ petition. Once it is determined, it will apply to all.
Yes.
So if the facts remain, if it is the fact that they are not pursuing with the tender in question in this writ petition 105.
No,
Let it
no.
go. What's there?
No, the question is.
The issue, that's what I mean. If the issues are similar, exactly similar, the terms and condition of the tender, they are not continuing with the tender.
No,
in this 105.
There will come a difficulty. That's why, Milord, Honorable Court passed that order on 25th of July.
What difficulty?
The difficulty is that, Milord, because of the terms and conditions that they had.
We're hearing it the same terms and condition which in the other writ petition.
Yes, Milord, just let me explain this, Milord.
Yes.
While the terms and conditions which they had formulated, and with that terms and conditions, we say in the writ petition that with that terms and conditions, nobody can qualify. Because these are so arbitrary and so, opposed to each other. Now after the bids were considered, Miller, they realized that the persons were not qualified. So they decided to go for fresh tender. So the anxiety that was expressed at the proceeding, Miller, is that if they again go with the same terms and conditions, then it will be a repetition of the same process, which will not be either interest of the state or in the interest of the public at large. Therefore, to give it a finality that as to whether these kind of conditions should remain or
No,
not.
that will be guided by the other writ petitions once we determine. This writ petition, when they have decided not to proceed with, what remains there? How
No,
can you challenge that?
No, they
You
have
just cannot, I mean, preempt them, though.
No, I'm not. My intention is not to preempt the state from floating a new tender.
Yes.
What I am on is
Today, if
No,
they
no,
don't
see,
want to, if today, why, today, admittedly, today, they are not continuing with the tender which you have put to challenge, what remains?
no. The question is this, Miller. If since the matter is coming up,
See, it may be taken care of in the other writ petition, same department, same terms and conditions, maybe a different thing.
there is a slight difference, Miller, because in the other writ petition, Miller, there is a corrigendum. Here, there is no corrigendum. In the other writ petition 93 and 227, there is a corrigendum into the terms and conditions. Here, the terms are not even. I mean, the no corrigendum were also even issued.
So
That's why, Miller.
you are not, I mean,
Well, that's why, Miller, I am saying things are similar. Let me just have 10 minutes, Miller, and I'll satisfy your lordship. What is my point about? If your lordship finds that this has become infructuous, it's absolutely okay, Miller. Your lordship will kindly come to the writ petition, Miller, page.
have you brought on record your submission?
Yes, my lord.
Well, that was
It's a
recorded in 20.
Part of the affidavit, my lord.
Okay.
That is also
My
part
lord.
of, and that was recorded
It's a
in
part
the.
of the affidavit.
Yes,
Yes,
my
yes.
lord. My lord, so,
Well,
So
But-
we'll hear the item 6.
Well, I mean, just to satisfy your lordship about the beginning of the thing, Miller. Item 6 is a better case, Miller. I'll show
Sir,
you.
we're not here to satisfy ourselves.
No. Well, I'll do that. Only two things I want to show your lordship from 105. Only
We're
two
here
things.
to provide justice to the people, not to satisfy ourselves.
Lordship will consider only two things in the 105, Miller. My contention has been, the petitioner's contention has been that the tender conditions are so arbitrary and so opposed to each other that nobody can qualify. Now kindly see what they have done. Your lordship will kindly come to page 48.
Suppose if you hear this matter first, do we go to hear that? Do we need to hear that again?
Perhaps, except for certain factual aspect, your lordship need not hear that again.
That's what I'm saying.
Yes, that's why.
Since the authorities are not pursuing this, they're proceeding with the tender in 105. We'll hear if it is a.
Brother, I am referring to this only for the purpose of giving the analogy, nothing else. I am not asking even for a moment that your lordship will adjudicate upon the tender. That I am not saying. Only for the purpose of giving the analogy, my lord, how and why the terms are opposed to each other. That's why I am pointing out to that. In item number 6, my lord, the factual aspects are very interesting. That's why here no factual aspect is projected. Only the irrationality in the conditions. That will take some time. To cut short the process, my lord, I am focusing on this.
Okay.
If your lordship will kindly come to page.
Subject to the determination finally.
Yes,
of this
yes.
issue, whether it's become infructuous or
Yes,
not.
yes, absolutely.
It's okay.
Page 48, your lordship will come.
48.
Yes.
Yes.
Page 48. Now, abhi bolne mat.
Mala, why I am saying, my lord, sorry for interruption. Mala, why I am objecting to take up first item number 7? Because here, my lord, your lordship may kindly note, no one qualified. Rest, my lord, 2 bidders they have qualified. That's why he's trying to take the advantage of item number 6.
No, there is nothing.
7, my
like
lord.
here I am
And
again
so far,
repeating,
my lord, item 7 is concerned, my lord. One, my brother is harping that corrigendum. Corrigendum, nothing but it's a clarification to the annexure B of the NIT. That's
my lord,
only.
why
Nothing
he
else,
is
my lord.
why he is gagging me? If I am trying to convince your lordship, why he is getting so anxious? Let me just point out
Let
the
us
thing.
see.
Page 48, your lordship will see.
Yes.
They in this page 48, they have given some qualification points.
Yes.
Regardless of whatever the conditions of NIT are, they say
NIT is for what?
NIT is for supply of certain goods, which they identify as eatables. Supply of millet-based biscuits.
Okay.
Page 24, your lordship will find.
For whom?
For Women and Child Development Department.
Yes.
Page 24, your lordship will find the first paragraph. Electronic bids under 2-bid system are hereby invited by the so and so for supply of millet-based biscuits. 45.
Hmm.
First paragraph. Millet-based biscuits to the Department of Women and Child Development, Government of so and so, and the supply will be made in ICDS projects. This is now there have been an elaborate terms and conditions set which runs from page 25 onwards.
Is it good for health, Mr. Naval?
Millet
Millet-based biscuit.
these are the dietary.
You can supply the High Court.
These are the dietary prescribed by the expert that these are healthy for the women's especially for pregnant women.
For women,
Yes,
not for the men.
I'm sorry, may not be for drinking purpose maybe, but for eating,
You find out if it's good for it's good for all the I mean irrespective of women and men. Explore supply to the High Court also.
Now from page 25 onwards, Miller, they elaborate number of terms and conditions by laying down how and why the persons may be eligible to bid. After everything is done, they include this page 40. And in page 48, they include certain terms and conditions, which we say are very incongruous to the terms and conditions set forth in the previous pages, in the previous, set of list. As well as these are also contradictory to each other. Now, how these are contradictory to each other, I am just trying to explain to your lordship. Your lordship will kindly come to page 40. In page 48, your lordship will find clause 4.
Is it applicable to all the bidders?
Yes.
Then?
And I am coming to it, Miller. Just I am trying to explain it to your lordship. Page 48, serial 4. Has your lordship got it?
40.
Page 48.
48.
Yes.
Yes.
Serial 4. Average turnover of rupees 10 crores each financial year for supply of micronutrient energy dense food for the last 3 financial years 2021, 21-22 and 22-23. Now, if somebody meets this criteria that average turnover is 10 crores, then he will earn 5 points. Next below, clause 5. Supply of micronutrient energy dense food to social welfare so and so for last 3 financial years. 1 state 5 points, 2 state 10 points, 3 state 15 points. Meaning thereby, if I had previously supplied to 1 state, then I'll get 5, 2 state 10 and so on and so forth, and I'll earn 25 points. Likewise, there is another clause that is clause 8. Clause 8 says net worth of the bidder during the last financial year, that is 22-23, as per audited balance sheet supported by CA certificate, up to 20 crores 5 points. And as against this particular clause, Miller, total points have been given 20. Has your lordship got it, Miller? Now, kindly note the endorsement down below. Minimum points required for qualification in the technical bid is 90 points. Now, even if I am successful in meeting all the qualifications which have been set forth in page 25 onwards, unless I can score 90 out of this entire table, I am out.
So according to you, even if it's if you combine all these points,
Yes.
it doesn't reach up to 90.
No, it adds up to 100.
Then.
Total points adds up to 100. The requirement is that if I do not constitute, if I cannot reach 90, then I am out. Now, what is the rationale behind this? Now, what is the rationale? In the item 6 also, 7 also, 6 also, the same table is under challenge. Now, what is the rationale behind it? I say that there is no rationale in prescribing these qualifying criteria because this also runs counter to what you have prescribed previously in the previous pages. They come up with a response saying that our expert committee has said so, and that's why we have done. Only one page communication, 1 page minute of an expert committee, so-called. They say that our expert committee has decided to do it, so we have done it. Now, what is the rationale behind doing it? There is no explanation. Now, kindly come to this page, my lord, how it is arbitrary according to us. If your lordship will kindly come to page 28.
Yes.
Now, page 28, your lordship will see clause L,
28,
28.
28.
Yes.
Yes.
Your lordship will see clause L. Clause L says the net worth of the tenderer shall not be less than 5 crores. Only as on 31/3/2023. So this is important, Milord, because the tender was floated in the month of February 2024. The net worth of the tenderer shall not be less than 5 crores only as on 31/3/2023 as reflected in the audited balance sheet. So therefore, somebody, according to clause L, somebody having a net worth of rupees 5 crores is eligible to bid. Now kindly come to clause N, down below, financial stability criteria. Financial stability certificate issued during current financial year, that is April 2023 onwards. Now, here is the difficulty, lordship. You are asking for net worth assessment up to 2023, 31st March. But the financial stability criteria, for assessment of financial stability criteria, you are asking for this certificate from 1st of April 2023. Why this period is left out in consideration of the net worth in para L? Financial stability certificate issued during current financial year from scheduled bank, preferably nationalized bank, mentioning the approximate value up to which the tenderer can undertake the contract. Financial stability certificate should mention the amount up to which the bidder is capable to do the business, and the same should be at least equal to or more than 50% of the total value of this tender. Now, if I am successful in showing that I have the financial stability up to 50% of the value of the tender, then I am capable to bid. Am I clear to your lordship? Now, the value of this tender is 5 crores. So if I submit a certificate from a nationalized bank that my financial stability is of 2.5 crores, then I am capable. Now, if you are saying that 2.5 crore is the financial stability certificate I am to show from 1st April 2023 onwards, then why you exclude this particular period in clause L, where you are asking for a net worth of 5 crores? Because you are giving a weightage that if I am submit 50% of it, I'm qualified. Then why is this 5 crores requirement here? And assuming for a moment that yes, that can also go on. Now, if the standard is understood as 5 crores and 2.5 crores, then why in page 48?
Yeah, this net worth of as close L said as on 31st 03/2024.
23.
The 23, yes.
23.
And then your financial stability certificate should
from April
that is
2023.
April.
Now, naturally, my lord, if I have done a business in the quarter commencing from 1st April 2023, then why you are asking?
When you have the net worth of 5 crore only, you will be having a financial stability in April.
No.
It is up to as on 31st March 2023.
As on 31st March 2023.
And the financial stability certificate will be on April.
From April onwards. From April onwards, because the tender was floated in the month of February 24.
April onwards, in the sense, when you have that 31st March till 31st March 2023, your stability certificate can be obtained thereafter only.
No.
When you have this till 31st March, as of 31st March, then April onwards you can have the financial stability certificate.
Very well. Then the financial stability is 2.5 crores.
Whatever may be.
No. We'll have to go by the condition of the tender. Condition of the tender says it.
You are well aware.
Well,
interpretation.
No. That is very clear. It is last line.
You cannot have your own interpretation.
No.
It is the author.
No. They are
author of the tender.
Very well. But they cannot give an ambiguous meaning to the terms and conditions.
But this code on of course subject to I'll hear you.
No.
But I mean cursory glance.
No. I am not saying these conditions are.
This net worth is up to 31st March 2023, and then common sense. I'm also not an expert. You might be more expert
No,
than
no,
me.
I don't claim
So
any
this
expertise.
financial stability certificate should be issued after 31st March only, 1st of April onwards.
Now,
When you have the financial year up to 31st March 2023 of the net worth, then only you'll have a stability.
well,
And that can be obtained from the thing.
well,
what you have
may I
to
just
establish.
may I
Yes.
just say one line?
Yes.
I am not showing clause L and M to indicate
Yes.
or even content that there is some contradictions here. What I am trying to say is that this L and N, if your lordship read together, this goes totally contrary to what they are asking for in page 48. If you are prescribing a limit that 5 crores is the net worth that I must satisfy, then why in page 48 you are saying that for turnover, for the sake of turnover, I'll have to produce a turnover of 10 crores? What is the basis of it? You are saying that I'll have to have a net worth of rupees 5 crores. Understood. And I'll also have to furnish a certificate of 50% of the value of the tender. Value of the tender is 5 crores. So I'll have to furnish a certificate, financial stability certificate, that 2.5 crores I am capable. Understood. Very well. Now, if this is the requirement of clause L and M, then why are you incorporating a clause in 48 to contain that my average turnover should be 10 crores? Kindly come to page 48. Page 48, clause 4. Average turnover of rupees 10 crores each financial year. Now, this goes entirely contrary to what you have settled previously. And on the top of it, Millard, you prescribe a qualification mark. Now, if a qualification mark is to be prescribed, Millard, that has to have certain rational basis with the objective you are seeking to achieve. And down below, your lordship will find clause 8. Net worth of the bidder during the last financial year, that is 2022-23, as per audited balance sheet, supported by CA certificate, up to 20 crores, 5 points. Now, out of these 20 points, if I am given only 5 points, I will lose entire 15 points. For what reason? You are asking me to provide a net worth certificate of 5 crores. Why are you incorporating these 30 crores, 35 crores and all, and giving so many points there? This is the incongruity with the previous conditions.
Yes.
So my emphasis on this, it will also be in this second case, Millard. Emphasis in these, Millard, these particular clauses your lordship will just take note of. Clause L, N and clause Q. Page 28, clause Q, your lordship may kindly see. Clause Q says, page 28. The bidder should have turnover of manufacturing and supplying of biscuits against the orders placed in their own names directly by the government department of any state, government, undertaking government of not less than 5 crores in a single year. So in a single year, you are requiring supply of 5 crores. If you are requiring a supply of 5 crores in a single year, then why are you putting a clause of 20 crores and 25 crores and 35 crores and all in the annexure B, page 48? During the last 3 financial years, that is 21-22, 21-23, 22-23. So average comes to 5 crores per year. I must have supplied 5 crores per year. The bidder should submit annual turnover statement for at least 1 year during the last 3 years of sale exclusively from the manufacture and supply of biscuits directly to the government department duly certified by a chartered accountant, and also submit the order copies and certificates. Now, if I have supplied to any of the government 5 crores in the last 3 financial years, I am capable. So this L, N and Q, if these 3 clauses are read together, Millard, in my understanding, I understand that tender conditions have to be understood for a harmonious purpose. Now, what is the logic behind this page 48? Where you are incorporating points of net worth up to 20 crore, 35 crore and 30 crores.
Yes.
So therefore, page 28 and 48, they don't go side by side together. They are conflicting with each other. And therefore, I say in the petition that these conditions are absolutely arbitrary without, and this suffers from total non-application of mine. To which the response comes that one-page sheet that some expert committee said, so we did. That is their stand in the affidavit. Only one annexure.
That's all.
That's all. Well, if I remember correctly, on one day when this matter came before your lordship's query to my learned friend was that if there is a challenge to the grounds, then what is your explanation to the plea of arbitrariness? My learned friend was yet to file their affidavit on that day. So he said that he will file an affidavit and he will explain. Now that explanation is still awaited. Well, this is the arbitrariness in the formulating the conditions, my lord, for which, my lord, I submitted that these particular clause in annexure B of page 48, these clauses are offending clause, and they in a way they are restricting participation, and the result is before your lordship. He has also submitted it on affidavit that none could qualify.
This is annexure B in the main conditions. What does it refer to?
Main conditions are in page 28.
Annexure B.
No, annexure B is to the annexure
Page
B.
48.
48 is supplementary to the NIT.
That's what I'm saying. What it has been referred in the main.
In the main, my lord,
main
page,
conditions.
Page 28, my lord, I do not find any reference. Page 28 nowhere says that unless you complete the
No,
requisite.
may not be page 28. It
But
might be some other clauses.
Yes.
Where it refers to annexure B. That is I'm asking. Then we'll get the idea of that thing, no? Why this has been required.
Well, in page 43, there is some 81, point 81 is written. And under that part 5, other standard forms to be used by the purchaser.
Mandatory requirement.
Qualification point is here, 83.
Qualification.
No, it only requires that these have to be filled up. These things have to be filled up. Page 43, serial 81. Has your lordship found it? It only says that these annexures have to be filled up by us. All these annexures have to be standard forms, have to be filled up by us. And therefore, the tender has to be.
Qualification points in scores. Annexure B.
Yes. Now, this annexure B is page 48. It requires, the tender condition requires that I have to fill up it. Very well. But if you are raising a benchmark that I have to complete, I have to reach 90. And if that is on the basis of such wondrous conditions, which has got no connection whatsoever with the other terms and conditions that you have said, there is the element of arbitrariness.
Tender form. Where is the annexure A?
Annexure A is at page 45. These are all standard forms, my lord. Annexure A through E, these are all standard forms that we will have to fill up. And if we do not fill up these standard forms, then our things can be
This
disqualified.
qualified points is also be filled up by you.
Yes, it also has to be filled up by you, but the total has to come to 90. If I am to qualify, then the total has to come to 90 because
What is the total of theirs? This
total of this is 100. First 4 is 5.6, 20, then 25 makes it 45, then 10, 55, 20, 75, 10, 85, 10, 95, 500. Total is 100, and out of 100, they say that I'll have to score 90. Now, how can someone score 90 if you are putting certain conditions which are completely in contrast with what you have laid down in the main tender? That is my case. One aspect. The second aspect of the matter is there is another non-application of mine which your lordship will find here. If your lordship will come again to page 48, common man's logic, turnover is something which indicates the volume of business that I have done in a particular year.
yes.
Now, My turnover is the volume of business that I have done in a particular year. Under no circumstance, my lord, my average turnover, my net worth can be more than my average turnover, because net worth is after paying off my liabilities, whatever remains with me, that is my net worth in a particular year. You are in clause 4, you are saying that average turnover should be 10 crores. Understood? If a man of, now for a moment, let us forget clause L, M and N. Let us only concentrate on annexure B, page 48. Even this page 48 will show the incongruencies. In the clause 4, you are saying, asking for average turnover of 10 crores. Very well. Now, if a person has to give an average turnover of 10 crores, wherefrom his net worth can be 35 crores? Because net worth is a resultant money that I retain or asset that I retain after clearing all my debts and liabilities. Net worth can never be a component which is more than average turnover. Am I clear to your lordship? So if you are asking for clause 4, if you are asking for 10 crores as average turnover, what is the basis of asking for 20 crores?
I think perhaps it's elementary. No question of understanding or not
That's
understanding.
it. So that is also, my lord, an arbitrariness in page 40. Now let me concentrate item 7. Item 6. Oh, for a moment, lordship, I'll just
let him reply.
Yes, I thought he will reply together, my lord. His affidavit, I'll just make a reference, my lord.
Okay.
His affidavit, page 13.
Affidavit.
Yes.
On behalf of 1 and 2.
On behalf of 1 and 2.
Yes.
Page 13 is the only document.
13.
Yes.
Minutes of the meeting.
Yes.
Yes.
And that is the document on the basis of which they say that this is the basis of formulating the terms and conditions.
Page number?
Page 13. Well, he will explain it, my lord. I am not taking his thing. But the only thing I say in response to it, I have said in my rejoinder, my lord. They have said that there are northeastern states, such things are being in practice. Such things are in practice. So, in my rejoinder affidavit, I have given the tender of Assam government. I have also sought leave of the Honorable Court to produce the other tenders. The Manipur tender I could get hold of. Where is the quotation number? That is the only stand taken by them. Now, in reply, my lord, I have stated in my rejoinder affidavit, my lord, I have brought on record the similar tender floated by government of Assam. There is no such condition. And one thing, in my affidavit, I said that I will be also craving leave of the Honorable Court to produce the rest of the things, my lord, rest of the states. Manipur tender I could get hold of. The lordship may kindly see this. Manipur tender, initially they included a condition like this, but subsequently it was realized that the condition is anti-competitive and onerous, and thereafter this condition was omitted. In my reply affidavit, annexure 4, I have given the tender of the Assam government.
Yes.
Now in Manipur, I have just now passed on to your lordship, my lord, the Manipur government tender, my lord. Here also your lordship will see page 2H. Anomalous condition was incorporated with regard to net worth and this turnover, and subsequently, my lord, they came up with a corrigendum. The corrigendum, my lord, they gave up that because they understood that this is anti-competitive. Your lordship may kindly see the corrigendum that also I have given to your lordship.
Which one?
Yes. Yes. In that particular folder, your lordship will find page 1, point number 4, page 2, point number 4H. The clause is removed for promoting healthy competition. The second page.
Bidders should have experienced supply. Bidders, which one?
Clause 2, your lordship will see. Clause 2, net worth of tenderer shall not be less than 15 crores. As on 31/3/2008, as reflected in the audited balance, net worth shall mean the defined so and so aggregate value of paid up share capital and reserve created out of the profits and securities after deducting the aggregate value of the accumulated losses, etc., etc. Net worth of only the entity bidder shall only be considered. The bidder shall submit. This was the condition in the NIT, but they later on they removed this because they realized that this is anti-competitive. So apart from the fact that this one sheet annexed to the affidavit that some expert committee said, there is nothing on record to justify that how these conditions came to be incorporated in the NIT and which runs contrary to what have been set forth previously. So therefore, my lord, my humble and respectful submission is that, my lord, apparently on a very casual look also, my lord, it appears that the clauses are not compatible with each other. And the result is before your lordship. We filed the petition saying that with these conditions, no one will get qualified. And they came up with this stand that yes, indeed nobody, because how can somebody qualify with this? If your conditions are so conflicting with each other. Now, subject to what my learned friend would like to make a reply together, my lord, it's up to him. Otherwise, I can focus on item number 6. Item number 6 also, my lord, the respondent states response is same, exactly that one page sheet. But item number 6 has got some additional features. There is a question of favoritism, my lord. That's why I wanted to place the facts. Only the value of the tender is different there and the subject item is different, but otherwise the things are exactly same. Exactly same. I mean, to the comma, semicolon, everything. Well, it's a possibly, my lord, this item number 7 is a result of copy paste error. That's why, my lord, probably it has been like this. It has got no connection with the conditions set forth elsewhere.
Where do we get the value of the tender?
In page 24, your lordship will find.
Show us what it is.
Value, your lordship is asking for value of the tender.
Yes. How do you know what is the total value of the tender?
Page 23A. Is the original, my lord. The type copy is that 23A. 500 lakhs, that is 5 crores.
Okay. 5 crores for each district or for all?
No, the entire value of the tender. Entire tender is of 5 crores.
Made it maintain integrated services project is spread in all 25 districts of the state. It's for all.
For all
districts.
all.
Yes.
Total value of the tender is 5 crores. So well, looked at this.
This tender is of
It is dated 20th.
21.
No, this one is dated, the Lordship will find the date at page.
21/02/2020.
Yes, 21/02/2024.
23.
24. Page 20.
Page 24.
Yes, 21/2.
21/2/2024. 23.
23.
Page 24. Well, there may be some mistake because 23 it says 24. Page 23, that is the opening page of the tender.
But it says it shows 23.
It is their document, Milord. Possibly there is a typing error. It can be so. But page 23 is the opening page of the tender.
Yes.
Opening page of the tender, your Lordship will find the signature.
Submission will start from 23 to 2020 and the last date of submission 14.
Maybe, Milord, the conditions were drawn in the year 2023, but it was not published. It can be so. But it was issued on 21st of February 2024.
Then in that case, it must be a mistake.
Must
It
be a
should be
mistake.
24.
24, man.
Because you cannot have the 23 and having a submission date of 23 to 2024 after 1 year.
Yes.
It's impossible.
Maybe Milord, the conditions were formulated long time back, but it was not made public or made.
What is the last tender?
Last tender was of
No. Last last page of this tender.
Last page of this tender is
There's
Milord, which one?
nothing, no signatures, still no signatures.
51. Page 51 is the last page.
41.
51.
No, 44.
No, 44 is the last page, but the annexure suite and annexure, Milord, it will go to.
No, I just wanted to know the authorities who has signed this.
Yes, director, women and child.
There's no signature.
But this was uploaded in the website, Milord, from where we downloaded it.
That's why.
Because it is e-tender, so we downloaded it from the website.
That's why this the date is not matching.
Yeah,
It's
in
23.
the signature,
I
Milord,
think it's a mistake.
My lord, if your lordship see,
You
my lord,
might have drafted this
my lord,
in 2023 and forgot to change the date.
Well, it
You
will-
publish it.
it will clear if your lordship turn to page number 25, my lord.
25.
Down below, my lord. Your lordship,
Yes.
tenders will have to be submitted online on or before 16 hours on 14/3/2024. My lord. There is a mistake 23, my lord. Yes, my lord. Admitted.
so they drafted it maybe previously, but forgot to change the date.
Page 25 or what?
Yes, 25 down, my lord. It starts from tenders will have to submit online on or before 16 hours
Right.
on 14.
On the top, first paragraph, page 25. Tenders will have to be submitted online on or before 16 hours, 14/3/2024.
Yeah. You have top.
Tenders will have to be submitted online on or before 16.
So that's a mistake there. And annexure B is also full of mistake. They start with the mistake with the date and mess up everything.
23 to 2024. But in page 23A, you said 23 February. You in page 21, you said 14 March.
Well, the signature, your lordship may kindly note. Digital signature, it is signed digitally, my lord. 21st February 2024. Page 23.
No, that's what I'm saying. In the last paragraph, page 23A, it says submission of tender will start from 23/02/2024.
Yes,
And the last day submission shows
14/3.
14/3.
Correct.
But
Yes.
in page 25, tenders will have to be submitted online on or before. Okay. On or before.
Wonderful.
Okay,
Yes,
okay.
14/3. Correct. ma'am.
Okay, I told it. Okay.
So, my lord, I think, my lord, I have completed the argument as far as this is concerned. Now, if my learned friend wants to make a reply together, my lord, then I will go
No,
to
what
it.
about this? Item 6.
Then yes, then I will say that.
Same thing.
Same thing, but there is an element, my lord. Additionally, we took the plea that these conditions have been set up at the instance of two interested parties, and they were made party respondents in the case. But they were made party respondents in the case. Now we say that since we were not sure at that point of time, we said that the parties like them are interested and they have done this mischief.
Let us see then in that case.
Yes.
93.
93.
This is. Where is the tender? Here?
In
Page-
93 tender, your lordship will find at page 29.
Hmm. 29.
This is also 20th February 2020. Same.
Same day.
Same day. Only difference is with the value of the tender. Value of the tender is only different.
20, 22, 20. This is 21st or 28th?
This is 20th, 20.
Earlier one is
21.
21.
21.
1 day ahead.
1 day.
This is for
This is for supply of rice and pulse based energy food.
Kheer.
Kheer and puffed rice fortified with minerals and vitamins. The value is only different. Lord.
Value is
Here the value is 10 crores. There the value was 5 crores. Here it is 10 crores.
this is also for entire state. I mean
Yes,
district.
yes, yes. For it.
All the district.
Yes.
Okay.
Now,
So the condition
same condition. Lord.
L
Here-
and M, page 34.
Yes. Page 34, your lordship will find the
Page
conditions.
34 and L.
L will be at
N
page
and
33.
Q.
Yes. L, Q and M.
Page 33, 34.
33 and 34. Page 33, sorry, 34. L,
That's what I'm saying. L, N and Q.
L,
Same.
N and Q.
And the
And the table will be here at page 50.
annexer.
Yes. Annexure B will be here at page 52.
Same.
Same. Exactly same. But two conditions were modified by corrigendum. That I will show to your lordship. Two of the conditions in page 52 was changed by a corrigendum. That I
Which condition?
this is मतलब the এখানে এটা আছে 105 টা বার করো 105 টা বার করো in
Earlier one is serial number 4,
5 and
5
8.
and 8.
Here also 4, 5 and 8.
4, 5 and 8. Then
Now out of this
rest you are not.
no only clause 4 in page 52.
Why saying is 4, 5 and 6, 8.
Yes.
It's incongruous or it's the contradiction to the
Both
contradiction to the main clauses in L,
M,
N and Q. That's why.
yes.
So rest it is not
And
may
also,
not be contradict. Therefore, you are not taking any.
no, there is
Let's
also
say other serial. I mean
other is also
other
contradict-
points.
Other is also contradictory.
It's okay.
And two of the conditions they modified
Here.
by issuing corrigendum.
Which one? Where it is?
Now the corrigendum is in challenge in item.
It's okay.
Item-
Where is the corrigendum? It's page.
No, corrigendum is not in this petition. We filed a separate petition for
Okay.
that.
So what is the addition? I mean ground here. Challenge of
Corrigendum.
no, not this one.
Oh, in the
You
additional,
said you have this additional
yes,
grounds.
additional ground is the pilot. We said that it has been issued for the purpose of protecting the interest of two private parties. who are respondents? Who are respondents 3 and 4? Now, kindly see now the chart of events below. I filed this writ petition.
Who are the respondents?
3 and 4.
Are they?
Madam, that's why I'm saying it's a very interesting thing. They appeared and they disappeared. They appeared and thereafter disappeared.
Who appears for them?
These two respondents.
Ah.
Now I filed this writ petition. These two respondents come with miscellaneous applications. Your Lordship has seen so many miscases are there. They come with miscellaneous applications asking for vacating the interim order. Interestingly, till date, Milord, state has not filed any miscellaneous application for vacating the interim order. It is the private respondents who come and say that the interim order should be vacated.
They have participated.
They have participated. We said that it is at their instance that these conditions are written, and it will only project that these two parties will be selected. That is our contention in the writ petition. They come, file interim orders, applications for vacating interim order.
Why you are saying so? Why you are saying so? Why at the instance or behest?
Because these are the two parties who can meet such a condition, despite the incongruity. Despite we said that it is at their influence that this has been done. Look, I'm just narrating the facts.
How do you link it?
I'm coming to it.
Yeah.
Now they
Come first.
Yes, first. My lord, I have completed my first argument. Here also I'll finish it. They come with an application for vacating stay. The stay is not vacated for XYZ reasons. Now, in the meantime, they finalize the process. Because the stay order is that not to give the award, so award is not given, the process is finalized. And in the finalization process, they are the only two entities who are declared as the final beneficiary. Now, these are the two entities belonging to the same family, cousins. The owner of one company is the cousin of the other's owner. And they have done it in so beautifully that even if all these things are taken into account, it is only they, and I have stated on my affidavit after the disclosure has come, Milord, that the award, they have been selected. They have been selected at rates much higher than what have been quoted by us. For economic purpose, Milord, I have not disclosed the rate. Your Lordship can call for the records and verify it for your Lordship's satisfaction. But
you have also participated.
I have also participated. But I participated with the objection that these conditions cannot go into because these are incongruous, as I had submitted earlier.
And you don't fulfill also.
And no, I said that if these conditions are operated, then I'll not be able to.
You have participated.
Yes.
Your tender has been rejected.
Tender has been rejected because of these conditions.
Yeah.
And I said that
you filed the writ petition after rejection.
Before and after. After rejection, Milord, that's why Milord, the second writ petition is there. 227 is there. 227 is the second writ petition where I have challenged that their selection is illegal and my rejection because of these grounds is also illegal. That is why the second writ petition. Now, the moment, very interestingly, the moment the tender committee takes a decision to award the contract to them, they disappear. Your Lordship can note the order sheet. They have completely disappeared from the proceeding. They do not participate in it anymore.
It's
and the reason is, Milord, is for anybody's gaze. Now kindly see, on merit, Milord, my submissions will be what I had earlier submitted. And here also the government has taken the same very stand that one-page communication. Now, at one aspect I must indicate, Milord, this writ petition was amended and subsequent amendment, my learned friend has not filed any affidavit. And in fact, on 18th, when the matter was listed, his submission was recorded that he will not file any affidavit in the matter. That was the thing. But if your Lordship will again go into this thing, Lord, I need not repeat it to trouble your Lordship again, that how these conditions are incongruous to the previous set of conditions. So regardless of the vitiating other vitiating factor, on merit also, my submission will be this tender also suffers from arbitrariness. And this is total non-application of mine.
No, how do you say that this condition has been put in at the behest of the responsible 3 and 4?
I said that it is at their behest because they are the only parties. It was my hunch because we are business in the
No.
business.
Authority will not find out who and who else.
My lord, even if your lordship will reject my contention on this point, my lord, I think it is indefensible that the incongruity which I have shown to your lordship
That we'll see.
vis-a-vis the other clauses. I can repeat again,
Yes.
my lord.
Yes, that's all. That's the only additional. Then item 9.
Item 9 is the, my lord, since they were selected, my lord, that their selection is under challenge in item 9.
On what ground?
Item 9 is 227. Their challenge is on the principally on the ground. I am cutting short the other aspect, my lord. Principally on the ground that my rejection on operation of these arbitrary conditions are illegal.
Yes.
And secondly, the rates quoted by them are much higher than the rates quoted by us. They have disclosed their rates in the tender allotment. I know what rate I quoted. Your lordship, for a specific reference, my lord, I can draw it to your lordship's attention.
Yes.
I have stated in my writ petition that the rates quoted by them is much higher than the rates quoted by us. And it is against the public interest to allow settlement at this rate. Okay, দেখতে রাখতে বলেছিল ওটা কোথায় আছে?
That's all.
That's all.
Any case laws you would like to?
Already I submitted one because this matter was also hard ones. One judgment, on a very short point, my lord. One judgment from our honorable court. Probably that is in the file also. In 105, maybe in the file of 105. Otherwise, if it is not there, my lord, I'll supply again. Well, it's a judgment reported in 2021 GLT 645.
91 this State of Assam.
Yes.
Chhatradhar Das.
My lord, the relevant paragraphs will be 36.
This way. This is GLT.
Yes. 2021 GLT 645. And the relevant paragraphs here will be 36.
36.
36, 39. 40, 43, 48 and 49.
39,
40, 43,
43,
48 and 49. May I read that? All the, the many previous decisions on the scope of judicial review vis-a-vis the conditions of tender was considered, my lord. And paragraph 36, your lordship may kindly see. What follows? Well, may I read it?
Unvetted discretion. Okay. Next para.
36, then 39.
39. 39.
Yes. There also, my lord, the conditions were set in such a manner that only a handful of entities would be entitled to bid and compete.
Quality will supply the discipline, yet there is nothing in the
Paragraph 39 at page 9 of the compilation, the last sentence, a mere presumption that smaller business groups would fail to deliver quality items. Which is in this case is merely schooling, cannot be the justification for excluding such entrepreneur from the realm of the contract. Because in their annexure 1, my lord, the expert committee, they have put emphasis on bigger entities. And the fact of the matter remains that also your lordship can note. I am one of the sitting tenderers, sitting suppliers in item 6.
James?
40, then 43. In the present proceeding, I find that the eligibility condition in the EOI has been designed in a fashion so as to ensure that the supply orders are received only by a few composite textile mill to the exclusion of all others. This is basically our case, which in my opinion would undoubtedly lead to concentration of wealth in few hands to the common detriment. Thereafter, page 48. Paragraph 40. And then paragraph 48 and 49. Here also, my lord, there is no justification, except for saying that an expert committee has said. What is the basis of that expert committee to say so? And how it is not incongruous with the previous terms? And I am one of the sitting suppliers, my lord. For last 7 years, my lord, I have been supplying, right from 2016 to the satisfaction of the authorities. I have also incorporated, my lord, the satisfactory completion certificates to the petition. The respondent authorities have certified that I have supplied the product to their satisfaction.
But it doesn't give you a right to continue.
No, I am not. No, I am not. I cannot claim any right to continue for all times to come. But the condition has to be with an objective of rationality. Now, what is the rationality behind these conditions? Because I demonstrate that these conditions are incongruous to this set of conditions. Now, what is your explanation to this?
We'll hear him.
Now, that he will not, but their affidavit is silent. He cannot bring now, after the affidavit is filed, Millard, he cannot bring now some other material to say that on these conditions it is satisfied. That is my submission. And 227, Millard, I am not repeating, the things are same, only the settlement, the decisions of the committee are in challenge. কোথায় আছে রেটটার কথা বলছিলাম যে কি পড়লিছিল কালকে That's all. And for a specific reference in 227, your lordship can see my pleadings in paragraphs, particularly, my lord.
Yes.
Paragraph 5, I have said that I have completed the things, and
no, it doesn't have any.
That your lordship, my lord.
It may not have any bearing. We'll see. They only should.
No, my past performance has.
Whether this is rational or not, is there rational behind it?
Yes.
To have this kind of points and which maybe appears to be which is
running contrary
to the main clauses of the tender.
Yes.
That we'll see. That is to be determined. Whether you have satisfactorily supplied or not, that is.
No, that is besides the point. That will not clinch the issue. Only thing is that they are whether they are capable of.
But one thing is, if certain conditions are put in, just because it's not palatable to you, or it's you may not qualify on that. You cannot say that this should be the condition. You cannot cannot dictate them.
No. I am saying that, my lord, to sum up, my lord, my submission.
If they can show that the conditions should have been put in place to choose the best, to select the best, then
They are free to do it. My submissions are threefold. First of all, the conditions have to have a logical relationship with the objective sought to be achieved to select the best. Now you have put certain conditions, how this is serving your purpose, that you have to explain, number one. Number two, as I have demonstrated, the conditions are running contrary to each other. And number three, even if the entire annexure B is taken into account, the concept of average, turnover and the net worth, these are messed up. Somebody's net worth can never be more than the average turnover. And in the process of awarding points, you are entirely obliterating the persons like us. That's why, my lord, I refer to this judgment that this is aimed at, because it is because of the plea that they have taken, that it is aimed at picking up the bigger entities and all. Why bigger? What is the rationale? Is there any logic? That's why the Honorable Court said in their judgment that there cannot be any rationale in understanding that smaller entities will not
but
be
in
able
this
to.
case, there was a record to show that it was only to give benefits to some persons.
No, here
The
also,
tender condition was
Here-
put in.
here also we have said that with these tender conditions, probably only these two parties will.
No, probably something different.
Now
You
that-
have to sure.
No, that probability
You are
has.
alleging that you have to be sure. Your
No.
assertion has to be clear.
Well, now my assertion has been proved beyond doubt because the result has come out and these are the only two entities which have been selected.
Okay, if they are qualified as per the tender condition, what's there?
So your lordship will hear him. If anything is necessary, my lord, I will make a short reply.
My lord, in item number 8, I am there, my lord.
Yes, but after that I can.
My lord,
Yes,
it is the
item
same
8.
tender, my lord.
Yes. Item 8.
8, my lord. My lord, only difficulty is this, my lord, in the online, my lord, it is cut off sometimes, my lord. If, my lord, my prayer is this, if your losses fix it on Monday, I shall come personally and argue. I shall not take more than 1 hour, my lord, less than 1 hour. If your losses fix it, my lord, I shall come personally, my lord. Today I don't come, my lord.
Monday is holiday here, sir.
I shall
You should have,
then, my lord, Tuesday.
sir, you should have mentioned in the beginning. Otherwise, we should not have. So he's.
No,
taking,
I can argue, my lord, no
Mr.
problem, my
Datta,
lord.
he's seeking for Monday. Not Monday, next. I mean, Tuesday. Monday is holiday here. Sir, Monday is holiday here.
My lord.
In that case, Tuesday.
My lord, if your lordship, my lord, Tuesday I have
Yes.
some difficulty. I have again come. 18th I came, for some reason it could not be taken up. I have again come.
Well, I have heard you. There's nothing. You have nothing much. I've considered you.
Well,
I've
my lord,
noted down your
in
argument.
that case, at least my learned friend should make his submission so that I can make my reply here itself. My senior friend, Mr. Sayawala, will do his later. Well, otherwise, I will not get a chance to reply to the
Sir,
submission.
are you, what is your ground in item 8? Are you taking the same
8, yes.
plea?
My lord,
Are you taking the same plea?
no, some additional thing that. My lord, first thing, my lord, this is a tender for supply of food items, my lord. This is not a technical tender. And that is worth rupees 10 crore. Now, in normal tenders, my lord, there will be eligibility criteria. Here, eligibility criteria are there. After eligibility criteria, my lord, if you also see clause L, my lord, in my petition, it is page 80. Net worth of the tender shall not be less than 10 crore only on 31/3/23.
Sir, I will hear you on 26. I will hear you on 26. You be here on 26.
My
Tuesday.
Yes.
In item 8, you just write. Mr. G.N. Sahiwala, learned senior counsel, assisted by
A.K. Sahiwala.
A.K. Sahiwala.
A.K. Sahiwala.
learned counsel for the petitioner. No, you just said on the prayer of learned counsel for learned senior counsel, Mr. G.N. Chahiwala, list this matter on 26/11/2024 for hearing, along with all this writ petition, writ petition 93. This 93, 105 and 227/20. We'll complete this other three.
Yes. Okay.
Yes, we will reply.
We'll complete this
Yes, yes.
by before 1 o'clock.
Yes, yes.
Much,
Doesn't look good.
much more.
Sir, we're taking your matter 126 along with this matter. We'll complete since they have already started. Mr. Datta has completed his argument.
My lord.
We'll complete this
Yes.
three other matters. All right.
My lord.
We'll hear you on
Yes, sir.
26.
Yes.
You come on 26. Please come on 26.
My lord.
Hey, please, your lordship.
105.
105. I'll start
All,
from
all, all.
105.
All.
My lord, I will start
Together.
from 105. Why my
Okay.
friend has started, as I've
Okay.
indicated, my lord.
Yes, yes.
My lord, in this NIT, as I've said, my lord, 3 bidders, my lord, they participated, but no one could qualify it, my lord. That's why the projection has been showed to place for lordship that we have put such a condition that no bidders can ever qualify, my lord. That was the impression wanted to draw, my friends, my lord, before your lordship, my lord. Now, other terms and conditions are same. Now, my friend was saying, my lord, addendum, we have added one more terms and condition, my lord. If your lordship peruse, my lord, the annexure A and B is already part of the NIT, my lord. It's a part of the document NIT. I can just demonstrate this. If your lordship sees, my lord.
Yes.
It was never incorporated later stage or in any time. It is a part of the NIT. If your lordship starts, my lord, NIT document from 24, my lord.
Yes.
Yes, my lord. Page number 1, my lord. Then is continues, my lord. Then annexure B, my lord. It's a page 25. It's a serially coming, my lord. It was never, my lord, incorporated later stage, my lord. It is already part of the NIT document, my lord. So it's very wrong to say that it was added later stage or it was incorporated, my lord.
No, that I have not.
You have said. You can have a review also. Not. You have said incorporated. It is already part of the NIT document. If your lordship see the A also, Mala, these are the standard format.
Okay. No one is disputing it.
Mala,
It's a composite tender documents.
yes, composite
It's
tender
also
document.
part of the main,
Yes.
annexures.
Correct, my lord. Now, my lord, we have to see, my lord, as my learned senior counsel was never argued, my lord, how this annexure B, the qualification point is irrational, my lord. What he was trying to, my lord, point out that this is contradictory to the terms and conditions put in L, the series, my lord. The contradictory, my lord. He has not argued on rational or irrational, my lord. He has not said, my lord, this annexure B is irrational. How, my irrational, he has not explained. He is only referring to, my lord, network and turnover. That is not inconsistent with this, my lord, qualification point, my lord. Now, when you see, my lord, this L, my lord, the terms and condition of the NIT, page 28,
Yes.
my lord. It starts the words, my lord, the network. And network and the turnovers, as is said correctly, is different, my lord. Network is the, my lord, maybe your financial sound, the capability of survival, my lord, in financial field. And so far, turnover is concerned is the total of your business in a year, my lord. How much business you have done it. Not the profit, my overall business, my lord. That makes the difference, my lord. Now, my lord, when we see, my lord, annexure B, it talks about, my lord, turnover, my lord. You also may kindly see, my lord, which my friend was saying, my lord. He was trying to distinguish, my lord, because here, my lord, network, my lord, says 5 lakhs, but we have said turnover, my lord, 10 crores, not the network, my lord. If your lordship see the, my lord, this L and my lord, the annexure B, my lord. Average turnover 10 lakhs, my lord. It's not the network, my lord. Turnover, my lord. It's talking about your business of a year, my lord. So, my lord, this cannot be said it's a contract to my lord L1, my lord. As your lordship rightly said, my lord, this N, the financial stability, my lord. Now, financial stability, my lord, is, my lord, synonymous to, my lord, network, my lord. Your financial stability, my lord, is same, my lord. In commercial language, my lord, turnover, financial stability is same, my lord. Now, it talks about, my lord, with effect from April 2023. Whereas in turnover is network, it says, my lord, 31st/3/2023, as on, my lord. As on, my lord.
So let's read the last part. Up to which bidder is capable to do the business, and the same should be at least equal to or more than 50% of the total value of this tender.
Yes, my lord.
This is the problem.
The financial stability approximate value which may can undertake contract financial stability certificate should be mentioned amount which the bidder is capable to do with the business, and same should be at least equivalent to the 50% of the value of the tender committee. Now, my lord, as I said, it's 100 crores. That means 10 crores. So he must have at least, my lord, 5 crores. That is the minimum, my lord. As I said, my lord, the network, my lord.
Yes.
Network, not the turnover, my lord. You must have a financial sound, my lord, to do business, my lord. That exactly was sought here, my lord. Now, if your lordship see, my lord, this page 48, which bothering them, my lord, because referring to, my lord, this 105, taking fast, they want to project, my lord, we have inserted such a condition, my lord, no one can, my lord, fulfill this terms and condition. Whereas in others, my lord, many bidders, they have qualified, my lord. That's why. Enough. 2 is enough, my lord, for qualification.
That was our stand.
No, no, no. Verbal submission will not suffice. That must be in the written form. Anyway, now, my lord, qualification, my lord, this is point was average turnover 10 crores each financial year for supply of micronutrient energy put for the last 3 years. We have given, yes, my lord.
You may be correct.
Yes.
So far as serial number 4 is concerned.
Yes.
Serial number 4, 11, L and N. But come to serial number 5.
5, madam.
Supply of micronutrient leverage dense food so and so, and SCTs for last 3 financial years so and so.
My lord, these are the same with, my lord, what you call paragraph 4, my lord. If your lordship see the 3 financial years, my lord, the same, my lord. 2021, 21, 22.
This also we may skip.
Yes.
But come to GQ. The bidders should have turnover manufacturing supply of biscuits against the order placed in them so and so 5 crores. You read the Q? Come to Q.
Yes. A bidder should have turnover manufacturing supply of biscuit fortified against the order placed in their own name directly by the government department of any states, government or UT government of not less than 5 crores in single year.
During the financial year. Then
Yes.
come to
During the last financial 3 years.
Serial number 8.
My lord, if your lordship see this, why they have put it 5 years. If your lordship see, my lord, the network also start from 5 crores, my lord. The serial number L, my lord. If your lordship see, is also start from, my lord, 5 crores.
See, page serial number 8. Net worth of bidder during the last financial year.
Yes.
As per Auditor General report CA, up to 20 crores, 25 crores, 30 crores, 35 crores. If your requirement is of 50% of the net worth, why you need this 20 crores, 25 crores, 30 crores, 35 crores? It is appears to be irrational.
I can understand, my lord, this because they have used the word net worth, my lord.
Yes.
Instead of, my lord, it should have been turnover, my lord.
Turnover also it's
Well,
not of no point because that has been taken care in serial number 4. 10 crores.
10 crore
It's more
turnover,
than
my
enough.
lord.
That's why serial number 4 and 5 may not have that much. It has to be not that
Even, my lord,
contradictory.
My-
But
my-
8,
well, even we have inserted this serial number 8,
yes,
asking for network of, my lord, 20, 25
yes.
crores of, my lord,
And
giving point.
And
My-
most interesting is you just see here. Last one, bold one. Minimum points required for qualification in the technical is 90 points.
Yes, my lord,
Suppose
No.
a person having a net worth of 10 crores, 5 crores.
my lord.
You want that the person as per clause 8 that serial number 8 that for last 1 year financial year you must have the 20 crores up from 20 crores to 35 crores they will be having a 20 points. Your qualification requirement is up to 5 crores.
If your lordship is bordering, my lord,
More than 50
Yes.
of the 50%.
I can understand, my lord. Your lordship may kindly say up to 20 crores. It does not say, my lord, the 5 crores of network, you will be
No,
disqualified, my lord.
Obviously, suppose if you don't have this,
Right.
suppose a bidder have net worth of 5 crores
Yes,
in last financial year, which is the requirement.
yes,
All right. The average turnover maybe 50 crore, 100 crore, whatever. It's a net
if your
net
lord,
worth.
yeah, if your lordship is bordering, my lord,
Therefore, now, if you he may be eligible as per this clause 10, I mean N, L, N, and Q, right?
right,
But if you don't have this clause 8, serial number 8, you'll not have 90 points. This is because it consists of 20, right?
I can understand. What,
At best, you will have 80 points.
Correct.
So this will disqualify.
correct, what is bordering your lordship, my lord? Out
Yes.
of 100, if
Yes.
20 is minus, automatically, my lord, he is disqualified, right, my lord? That is bothering your lordship.
Yes.
Your lordship may kindly say, my lord, up to 20 crores, my lord, he is getting 5 points, my lord.
Hmm.
Has your lordship got it?
Yes.
He's getting 5 points, my lord.
Yes.
So if he's included, my lord, if he gets, my lord, suppose 85,
Hmm.
then he added 5 points. He qualifies, my lord.
No.
Yes, my lord. If he scored 85 marks,
No. Minimum points required for qualification technical is 90 points.
90 points, correct, my lord.
Total is 100.
Totally 100.
Yeah. If you get 95, you are disqualified. You have to get another 5 points. From where you will get it?
But at least he's getting some point, my
It
lord.
doesn't say
Ma-
net worth, turnover. It's a net worth.
Correct, my lord. Network, my lord. Yes. My lord, it doesn't say, my lord, ki minimum 20 crores. It says up to, my lord. It doesn't say minimum, my lord.
If you don't have that, if you don't have 20 crores net
Yes.
worth, whereas your qualification requirement is 5 crores net worth, as per clause N, L and N,
L is talks about, my lord, network of 5 crores, my
5
lord.
crores, then
Yeah.
your this up to which whether it is capable to business and the same should be at least equal to more than 50% total value of the standard. N. So it's a 5 crore. So you'll have your requirement is only 50 net worth of certificate of
It's a 5 crore, my lord.
2.5.
Yes,
2.5 crore.
my lord.
So you cannot have this if you don't have less than 5 crores at 20 crores, forget about thereafter, above that. If you have a less than
20 crores.
you will not get any point
No,
out
no.
of 20.
No, he's getting, my lord, point, my lord.
Yes.
He's getting point, my lord. Up to 20 crores, 5 points. Up to 25, 10 crores. Up to 30 crores, 15 crores, 15 crores, 15 points, my lord. Up to 35 crores, 20 points, my lord.
Yes.
So those who are up to
Below 20 crores, what is
Below-
the point?
5 points, my lord.
No.
Yes, up to 20 crores, my lord.
Okay, it's okay. Up
Yes.
to 20 crores.
Yes, it doesn't say
Say
minimum.
For example, 5 to 20 crores.
Yes, he's
Then
getting, my
he'll
lord,
get
5 points. He's getting 5 points.
So one,
But what your lordship is bothering,
50
my lord,
minus to 80, 85.
Yes.
So less than 90.
90.
You should not have put in here this bold requirements which have been bold given in bold letters.
Yes.
So this is something.
Now,
Yes,
my
you are right. Up to 20 crores.
yes, my lord. He's getting 5 points.
Yes.
Now, your lordship has to say another angle, my lord. Suppose this is irrational, my lord. How, my lord, this is discriminated to him, my lord? Because this will apply to all, my lord. And here is the case, my lord, at least two be that they qualified, my lord. What about their interest, my lord? They have qualified.
Not in this, in other case.
Yes, not here, man, not here.
You have
Not here.
you have not proceeded with because there was no
Because no one qualified.
no one was qualified.
Yes, no one
eligible
qualified.
candidates.
No one qualified, not because of serial number 8 could be another ground, my lord. There are another technical issues are there, not because of ground number 8, my lord. But had it been ground number 8, obviously, my lord, other two respondents they will qualify, my lord.
Yes, he may be correct. Not because of this main clause, because of the last remarks, the requirement of 90 points. It is well,
Your
no,
lordship is
well,
correct. Your
it
lordship
is not exactly a contradictory, but then when you read together,
No, your lordship is correctly saying that if these 20 points is taken out,
not 24, say
say 5 points,
15 points,
then nobody can
85. That's why I'm
yes.
asking.
Nobody will get this 90.
But then what I'm saying is not that contradictory to the main clause of L,
No,
9, N, and Q.
It is also contradictory. my lord. It is also contradictory because your objective is to get people who are capable of supplying 5 crores. Then what is the rationale behind this 30 crores? What is the logic? They are silent on their affidavit.
No, suppose requirement is 5 crores. That is the minimum. If you have a better network or having a better average turnover,
Exactly.
what's
Then-
wrong? What's wrong?
Yes. Now
That's why I'm saying only because of the stipulation of minimum 90 point,
that is one, and the wrong.
it may create a hurdles for those who have the up to 20 crores.
Yes. And
That's
otherwise.
the only point.
Yes. No. This point I'll also say because supposing your
Okay,
lordship is
okay,
saying-
I'll hear you. Let it
Ah,
continue.
yes.
You just want to clarify that's all. Nothing else.
Nothing else. Now, my lord.
Only that much.
Yes. Now, kindly see, my lord. Although,
But that will be a huge bearing on it.
my lord, kindly see that although the period is for 1 year, but is extendable, my lord. It can be extended for another 1 year. If your lordship multiplies, it's double, my lord. Now he's getting the benefit of that, my lord. Can you take note of that also? Now, my lord, another argument is forwarded that the terms and conditions were tailored in such a fashion that only the private respondent will be eligible. My lord, that is, my lord, without any, my lord, prima facie evidence. It's just a privately in the business, I can understand, my lord.
So, to the extent you may not be admitting it, but when reading this together,
my lord,
there is something contradictory.
Uh,
I mean, little,
but
not little. It will have a huge bearing because see, tender those having a net worth of 5 crores or up to 20 crores will be will get only 5 points, and obviously they will be disqualified.
Now,
So it appears to be not rational.
Now,
That's the point.
Yes, another angle you have to see, my lord. My lord, this is a supply of nutrition, my lord. It's a central sponsor scheme. The lordship knows, my lord, the topography of Arunachal, and also, my lord, the financial aids come from the central government.
Once your terms and condition appears not rational. How can we allow you to?
But the
proceed?
person, Mala, whom we are going to entrust, Mala, we must have a faith that he has capable of the financial
No,
stability.
no, nobody can stop you to have this 20 crores, 30 crores or whatever.
No.
Tender may be of 5 crores or whatever to get the best or select the best. You can put any conditions.
That's why, Mala, we have
Then
put,
why you are making someone at the initial stage, you are, I mean, at one point you are making someone eligible. Then putting a condition which goes against, I mean, which appears to, which takes away its eligibility. As per serial number 8 and the requirement stipulation in the last.
my lord, can I put it like this, my lord? Now that securing 90%, my lord, that will safeguard us, giving us full assurance that during, my lord, any reason, suppose the financial help is coming out not from the central government, but they have to carry on the business, my lord.
No, you
In
can
that,
you
in
can
that count, my lord, you lordship to see, my lord, greater, my lord.
Sir, you can have 100%, 100 point also to make them qualify, because it's to all every bidder. But you should not make someone qualified, giving a certain amount, and then thereafter you say that no, you will have to have this, though you may have this qualification. That cannot be.
That up to, that is the basic starting point of network of 5 crores, my lord. We have not said, my lord, this is the last, my lord. This is the starting, my lord, minimum, my lord. You must have a 5 crore of network
No, see,
for your stability, my lord.
in that case also, the tender has to have the rationale. Suppose the value is 5 crore. Why you need 20 crores, 30 crores?
My lord, here is a supply of 10 crores. Can be extended for another, suppose 20 crores. Now we are asking, my lord, how much we are asking?
No, that's why I'm asking, what is the rationale behind?
My lord,
What is the rationale behind of having a net worth of giving a point of 5 up to 20 crores when the 10-year value is of 5 crores?
that is the reason, my lord, that we have put minimum, my lord, must have a network of 5 crores, my lord. That is the reason, my lord, behind that. That is the logic behind. Because, my lord, if the tender amount is, my lord, 100 crores, if it is 50 crores, it comes to 5 crores, my lord. That is the reason that minimum you must have a network of 5 crores. Not the turnover, my lord. Turnover, my lord, obviously is, we have asked for 10 crores.
No, that is the problem. You see, serial number 8.
Understood, my lord, understood. That marking system, your lordship is boring exactly, my lord. I can also, my lord, yes. But considering this hyper-technical
No,
issues.
reading only, on the reading of this only. The language here, net worth of bidder during last financial year, 1 year, not even for 3-4 years, up to 20 crores, 25 crores, and then you are making it one of the qualification for technical bid. You must obtain 90%, 90 points.
This is the total point, my lord, for qualification. If your lordship has correctly said financial year for one last year, my lord,
Yes,
is
net
specific 22 and 23.
worth.
23 and 22 and 23, yes. It's a audit balance sheet supported by a CA certificate, my lord. It's a balance sheet, my lord. And balance sheet, I think they are too expert in putting the things ups and down, my lord. They are quite expert, but anyway, my lord, they think. No, they think.
He's a commerce graduate, he knows it better than. And otherwise also just one thing that as your lordship has pointed out, 4 and 8, these are also incongruous in the sense, and that's why arbitrary. If you are asking for net worth of
Man, why
5
not?
crores,
In
or
fact,
10 crores.
we'll not consider going into the small
Hyper-technical
negligible,
issues.
As you said, the hyper-technical thing will not go and will not consider will skip and we may avoid the small aberration, whatever there.
Yes, but no, what I was trying to say.
Rationality, as you have said, will have to determine.
Yes. Now the rationality, irrationality is here, my lord. average turnover, you are asking for 10 crores.
It's okay, I've understood.
Now, if the average turnover is 10 crores.
Sir, I've understood. I want to get it from him.
No.
I want to explanation from him.
Yes.
I've taken note of your argument. Hopefully, perhaps I have understood.
No.
what
There
you
is-
have argued.
Well, your lordship is vastly
I want to get it
experienced.
from.
Now, another Malo he has raised Malo he is the lowest bidder Malo. Now, as your lordship knows, financial bid is open, my lord. Now, obviously, my lord, once the financial bids are open of the private respondent, obviously he's the right person to know whether my bid is higher or lower, my lord. Now, if my friend is harping on this, my lord, that he has stated, my lord, there is no whisper about, my lord, that this present bid, my lord, is the lowest bidder, my lord.
No.
No, you have never said. If you are annexing this, my lord,
Perhaps he
my
has
lord,
missed out his notice.
No.
I am referring to the specific paragraph. Your lordship will can listen.
Now, if you are pointing out this one, this is a, my lord, extended contract. If your lordship sees the comparison of the
This is
rate,
of
my lord,
last year, sir. This is of last year. I am not referring to it.
this has been
I have
extended.
said
This has
in
been
the-
extended.
In the present contract, their price have been quoted as rupees 81 at something. Well, that is the settlement. In my petition, page 15, paragraph 16 and 17, I have said that
No.
my rates are competitive than
I
the.
think we may not go into that.
No, it is
We may not
also,
go into that.
it is also an element of public interest involved in it.
It's all right. We'll consider your submission, but
Yes.
we may not go into, all those issues, whether you are lowest or highest.
Yes.
The
Yes.
issue which we need to determine,
Whether it is arbitrary or not. Reasonableness.
I want
Yes.
a good and satisfactory explanation from the government.
Yes, that's it.
So that it can be saved. Tender can be saved.
Tender can be, if your lordship sees, Mala, that minus of the meeting, which my friend said, that only the expert committee they have decided without any having a basic knowledge about this, my lord.
But
My
appears
lord,
to be the same things are going on. We need to, it's something different we need to change.
because
I remember always we will try to have whenever there is a policy, we used to get it from the other notice state.
correct, Mala, we have
Once you get it, we
Mala-
just cut and paste.
Mala, we have abstracted that portion only which are favorable to us, Mala. Not
Yes.
is a cut paste, Mala,
Your
totally
state
copy
is-
paste, Mala.
You
We
are,
have,
you are not, your state is much more ahead now. You are not behind. So stop having a cut and paste.
In the cut and paste mill, this problem has come.
Okay, we'll continue at 2.
two, my lord, yes.
Think
Oh,
about
my
it.
lord, two, my lord, I have BC in division bench, my lord. So I will just cut short, my lord. Now, this minutes of the meeting, my lord, they had minutely observed taking notes of entire notice, my lord. The procedure, which are the best, which are the terms and conditions.
Yes.
And considering all these things, my lord, they have adopted. Now he's saying that only the tax expert committee, my lord, without applying their mind, they have just adopted this by putting annexure way. That is not correct. It speaks clearly, my lord, the minutes of the meeting. That's correct, my lord.
Well, your lordship is going to hear me again at 2.
Nothing to be heard. It's okay. Any, would you like to place some judgment?
My lord, yes, my lord.
No, this will be listed along on
My lord-
Tuesday again.
I have given the list of books, my lord, yes.
But Tuesday, my lord, I'll have some difficulty.
You can have a BC.
No, I'll be out of station. I'll not be even at Guwahati. I mean, before Meghalaya.
No, Tuesday is, it's almost, in this other 3 repeats, I have heard you. It's okay.
Yes.
We'll hear on Monday, we'll hear, Tuesday, we'll hear
My lord, in so far as my writ petitions are.
Mr. Sahewala only.
Yes, my lord, so far as my writ petitions are concerned, if your lordship, conclude the things today itself, then I need not appear on 26th again. Because
No.
26th, I'll be in Meghalaya High Court. my
No,
lord.
this will be listed along with Mr. Sahewala's writ petition only. It has to be decided together. We'll hear him and we'll decide it better together.
In that,
In that case, do we need to segregate it?
your lordship may segregate it also. But so far as the hearing on these 3 petitions are concerned, these may be taken as over. He will address his own, he has.
Unnecessary again.
Or your lordship can list it together if I.
You don't have to come, it's okay. We'll say that the argument is complete. in 3 items.
Well, there are interim orders that will continue till then.
No, it's okay. Argument of the learned senior counsel, Mr. S. Datta, is completed. Mr. No, it will say, heard Mr. N. Datta, S. Datta, learned senior counsel assisted by so and so for the petitioners, huh? And also Mr. Arichanabam, learned additional advocate general for the state. Non-appears for the respondent number
3 and 4.
3 and 4, despite filing of internal application as well as internal applications list. Hearing concluded. However, let these matters be listed along with writ petition 115 of 2024 on 26. If you want, you have to, yes, you have to reply Saiwal also. And it will be same together. If you sitting there, you may place on it.
My lord, you will not make any reply against me, my lord. I understand that this is concluded.
It's okay.
My lord, in item number 8, my lord, interim order may continue. My lord.
26.
115 in interim order may continue, my lord. 115 as well. Writ petition 115 of 24, my lord.
It is say
Yes.
interim order
My lord.
shall continue
My lord.
till final conclusion of the entire matter.
Let them have some service.
Another side also took the consent.
On the that's right. On the prayer, Mr. M. Bagra, learned counsel appearing on behalf of Mr. Esquire. Learned counsel for the respondents. And prayer not being opposed by the learned counsel for the respondents. List this matter
After 2 weeks.
4 weeks.
Okay.
After 4 weeks.
Much obliged.
Fiction is here. Yes, sir.
Yes. This appeal is referred against the judgment and order passed on 9/9/2024 in title appeal number 03 of 2020.
Yes.
Now, here in the case was tried before the senior division civil court and it was decided in my state. That is on 16/5/2020. Now, since the judgment was pronounced on 9/9/2024, we have filed appeal against the judgment. In the meantime, we come to know that a decree was passed after expired 1 month, that is 16/10/2024. So we withdrew the earlier petition, appeal petition, and we filed this present 04 RS. Now, since it is filed under section 100 of CPC, it is an statutory appeal. And before coming to law point, that is formulation of substantial law point, let me to draw the background and I'll highlight it here. Initially, this case was instituted before the CGM And the case was registered.
CGM or civil judge?
Civil judge. Civil judge. CGM come civil judge, senior civil judge. And they have filed. And the case was registered. It was registered as 30 of 2017. After getting that, the present appellant was also filed a title suit. It was registered as 39 of 2017. Now, in both the cases, search was framed. Issue was framed. After that, both the cases were clubbed together. Amalgamate. In that, we have challenged the giving of gift deed to the present respondent by the Yama Toki. And we have challenged and we made Yamazuki as respondent number 2 and copy was served and they did not contest itself ex parte order was passed. Now, and he did not contest. After that, the basic dispute arose from the filing of title suit number 30 of 2017. Now, title suit 30 of 2030.
Who has filed the title suit?
Present respondent. Present respondent and myself, I also filed. My case was registered as title suit number 39 of 2017 and her case was registered as 30 of 2017. Now, both the cases have been clubbed together, amalgamated, and here is also ordered when it was clubbed.
It's okay. In that process, it will days to hear this matter. It will take days to hear this matter. Listed for the first time. Listed for the first time. This is listed for the first time. So?
Listed for first time. And earlier, this is second time. Earlier also it was listed. And on that day, caveat was discharged.
Yes.
Now, the basic law point is arose from the petition of the 30 of title suit number 30 of 2017. Huh? 110. Yes. Page number 107. This is the petition. This case has been registered as 30 of the 2017. Here, what is the court title? For a decree of perpetual injunction against the defendant number 1, thereby restraining him permanently from encroaching the plaintiff land measuring 374 square meter at B sector, Premnagar, Nahaulagar, Papumpare, district, Arunachal Pradesh, duly allotted to her by allotment number such and such. For a decree of mandatory injunction against the defendant number 1 to demolish vacant the part of the building, RCC structure and wine shop constructed illegally in the allotted plot of plaintiff land. Now, in the prayer, in the premises, page 112, in the premises of the above, it is most respectfully prayed that your honor may be pleased to, for a decree declaring the wine shop and RTC building structure of the defendant number 1 as illegal and constructed within the allotted plot of the plaintiff land 374 square meter. For a decree to dismantle the wine shop and RTC building structures of the defendant and cross in the allotted plot of plaintiff land, or to order directed city department land, government of Arunachal Pradesh is allowed to verify the actual enforcement of the plaintiff's plot of land. Be pleased to direct the defendant number 1 to pay compensation as to loss of income and damage to the rent house of the plaintiff and cost of the present suit, and for any other relief as the plaintiff entitled under the facts and circumstances of the case. Now, she has filed this petition. In this petition, they have not mentioned the boundaries of the land. No boundary. As per Order 7, Rule 3, it is clearly written that in the case of immovable property, the description, the identity of the land or property should be described. Whereas in this case, they have not mentioned any description of the land. Now, wonderful. Another, they have what annexers they have annexed. The Exhibit 6, page 161. Page 161. And page 163 come to the point. Here they claim plot dark number. There is no plot, no dark number, no seat number. And north plot of T Apum, south plot of Tamut Tagin, east NS52A. See, NS52A. Where NS52 is located? There is no NS52 in the Prem Nagar. Now, west plot of Nabu Anna. Now, again, on the same plot, I have also been allotted 76. Come to the page number 177. Here, plot dark number 50, map sheet number J/22, land area 76 square meter, location. Now, note, sheet number 1/22, south, dark number 50, east road, west, dark number 50. This is my allotment. Now, whatever building I have constructed, that is upon the plot where I have been allotted. There is no question of enforcement here in the construction. And now, without possessing the land, they have filed perpetual injunction to restrain me without possession. Can it be possible that without possession, a person can file perpetual injunction? Now, that is a certain law of the Apex Code that without possessing the land, a person cannot file perpetual injunction. That is a settled position of law. Now, in this judgment, here, Well, passed the impugn judgment dated on 9/9/2024. The Honorable Judge has taken some unexhibited document in the court. That is in page number 270 to 282. Whereas this 270 to 282 has completely rejected in this trial court. It was not marked exhibit and it was not produced. Then
What documents are there?
huh?
What are the documents? Page 72.
That is give deed. Give deed was not exhibited. Then give deed was not exhibited, and they have taken the statement recorded by police, and police was not made as party to witness of the case. G. Basar. There is inquiry report submitted by G. Basar Ayo, P.S. Nahalo. So, all this document was completely rejected by the trial court. When it is already rejected in the trial court, they have in the judgment, entitative judgment, impugn judgment has been passed through the unprohibited document. They have referred the G. Basar case, whereas G. Basar was not made a witness. That is another. Another issue comes that I occupied the same plot of land since 1985. At Pramno. Then, when I was in the, before I married, I occupied that plot. Now, Yamachuki was married while I was in the plot. There was a divorce settlement on 29/10/2000. Now,
Land in dispute is a government land,
government land,
allotted land.
allotted land. But allotted is also, we are disputing it, how it has been allotted. Now, thing is that Yamasuki, as per term and condition of the divorce, that she cannot claim any property, landed property, or any property of the present appellant. Now, most wonderful is that Yamasuki left my house on 29/10/2000. She is no more with me, and the land is never under her possession. Now, she already married with Tamil Tar, alias Tamil Punya. She was the wife of someone. Now, in 2006, she applied for land allotment, and she has been allotted. Now, my question is that, without possessing the land, can he give a deed and allotment while I am in the possession? How the land was allotted to her? That is the illegal, because entirety of the land is under my possession. Now, it is a conspiracy that they got the allotment. She is the wife of someone, but in 2006, she has written in the allotment, wife of Davin Choki. She was the wife of Tamakonia. Now, the impute judgment, it was not categorized. When it was allotted, although the land was under my occupation, in judgment when we read that the allotment might have been met before the settlement was done. Now, in the court, when two parties have consented, agreed, and the term and conditions of the divorce, then whether a third party can nullify that decision, because nobody made the appeal against the decision, wrongly or rightly, it was accepted by both the parties. Now, my question is that 2006, she was no longer my wife. She never possessed the land. How the land was allotted in her name, without possessing the land? And what happened? She had transferred the land by way of deed to the present respondent. So, I have prepared the appeal ground. Appeal ground is page number 22, ground of appeal, page number 20. First ground, for the learned court below has here in law as well as in fact in decreased with land in favor of the plaintiff respondent here in appeal. For that, the impute judgment is contrary to law and material placed on record. As such, the impute judgment and decree is liable to be set aside in court. For that, the impute judgment and order is solely based on inadmissible evidence. For that, the impute judgment is perverse. For that, the court below is here in concluding that mere eviction suit is maintainable despite the plaintiff is not possession of the suit land. It is admitted position that plaintiff is not in possession of the suit land. The remedy of the plaintiff is to file suit of possession and the title in addition of the injunction. The plaintiff has pleaded in paragraph number 7 of the plaintiff that the defendant encroached the plaintiff land and also threatened those in the rented house. In fact, almost all of them left the place. All the previous witness, period 2, 3, Tayumo 2, period 4, 3, Tokosol, period 5, 3, Likaredia, period 6, Srimoti Devi, all are family members. Period 7, Mission Yeka, in examination itself has categorically admitted that the Assam type house in possession of the defendant apparent gave in. Because they never said that the entire land was under their possession. No one said. It is a settled position of law that mere injunction suit without declaration of possession title is not maintainable. The remedy of the plaintiff is to file possessory suit or title suit. The plaintiff who is out of possession cannot seek the relief of injunction simpliciter without claiming the relief of possession title, and hence finding of appellant court is wrong in regards to the maintainability of the suit in issue number 1 and against the settled legal principle. Law has clearly settled that without possession he cannot file for the permanent injunction. For that in title suit number 39, yes, the appellant has implemented Yamatar Tamil, the purported donee as defendant number 2, but he did not contest the case and suit was presented ex parte against her. For that, the appellate court has error in finding that the plaintiff's name is already registered in the government record and she is in possession of land allotted to her by the government, and plaintiff need not required to file title on the suit, which is already in her name, and decide the issue of the maintainability in favor of positive. The entry in the revenue record or mere mutation of land is not the automatic ownership therein. It is certain legal position that entry in revenue records and the mutation certificate is only for the fiscal purpose for paying land premium and land rent. The mutation in revenue record neither creates nor extinguish the title, nor does it have any presumptive value on title. That the appellate court has herein deciding that the defendant appellant herein did not raise any complaint before the deputy commissioner against the allotment given to the plaintiff, who is implied that defendant is not against the allotment of land in favor of the plaintiff. Now, this is all these other ground. After that, I have separately drawn the substantial question of law. That is page 30. Come to the page 30.
Yes, 1 to 6. Yes.
Yes.
Thirty minutes is enough. 30 minutes is enough. Yes.
May I please, Your Lordship?
We'll admit this,
Lordship.
this substantial question of law.
Lordship,
And,
I have an objection
including-
on the substantial question of law.
Yes,
On the substantial question of law.
yes,
Number one substantial question of law, which he has said,
yes.
is that if there is a cloud over the title, if there is a cloud over the title, then mere suit of injunction is not maintainable. That is what his question is, whether appellate court which will reverse the finding of the original court in
Yes.
directing maintainability of suit has acted contrary to the settled legal principle emerging from binding precedents. The suit of mere injunction is not maintainable when the title of the plaintiff is in dispute.
Yes.
The first appellate court has given a finding that when there is no cloud over the title, because the suit land is a government allotted lot, at no point of time the defendant, that is the appellant herein, was allotted the land. Your Lordship will find it very interesting to note that the entire plot of land was actually 450 square meters. 450 square meters,
Yes.
out of which in 2006, 374 square meters were transferred to me, and I was given allotment on transfer. The rest of the 74 square meters, he had been given from the same person, that is his ex-wife, Srimati Amma Soki. That was the ground, the honorable, there is already a finding that there is no cloud over the title. So if there is a question, this becomes a question of fact. If this is a question of fact, can this be a substantial question of law? This number one I'm saying. Number two, regarding the precedent that the party who is admittedly out of possession cannot seek relief of injunction. The prayer which my learned friend has read out in the plaint, I am aware it is happily worded, but he has said dismantle the structures of the defendant. That was one of his prayers. Now it is a settled law that it is not the substance of the, it is not what is pleaded, not the words, but the substance of the pleading. The reason why it is so is because the other party should have the opportunity to show whether the relief proposed could or could not be granted. it is not the language itself, but the substance of what is being asked for. The only requirement is that the other person should be aware what they are fighting against. So therefore, it cannot be said that there was no relief of possession that we sought. This is also again, and then he has said that he was always in possession. This is a concurrent finding from the trial court, as well as even though in the trial court we lost the case, but there was a finding in issue number 3, which is at page 75 of this petition. This is the this is the page 75 is the finding of the learned first appellate court. From the issue, I will not go to that at the moment, Lordship, but what I'm saying is in the issue number 3, whether or not the defendant had encroached upon the land of the plaintiff, that issue was found in my favor, even though the verification of the police was not taken into account. It was found from the statements or the depositions, which was not shaken by them, that there was an encroachment from his part. That was decided. This was also a finding of fact. So therefore, it cannot be said that we had not asked for possessory rights. Now, with regard to the para 15.3, in which he has said that it is merely an entry in the revenue of the allotment is merely an entry in the revenue code, and it's not a substantive right of ownership. This also, the learned first appellate court has found that grant of allotment is not a mere entry in the revenue, not for the purpose of revenue collection. Your Lordship knows in the state of Arunachal Pradesh, the allotment is a right of ownership, at least which can be filed only against the state. Otherwise, he has clotted with all the ownership rights. It is a substantive right of ownership which is given. So it is not a mere revenue entry. So therefore, there is also a clear finding of fact that the giving of allotment is a substantive right of ownership. So therefore, this is also a question of fact which has been decided. Then, Your Lordship, the arrest, he has said that the unregistered gift deed, as well as the report of the police. In spite of that, could that be taken into account? My humble submission is that even though these were taken into account, this was not the ratio decidendi for the case. The ratio decidendi for the case was the allotment order and the fact that he had also gotten allotment after transfer from his ex-wife from the same plot of land, a portion of the land. This was the reason. Even though this has been taken into account, the reason why the case was decided in my favor is that government had the authority and government had allotted the land to me. So this is also a finding of fact. It may have been wrongly done, but it is not a substantial question of law. Then the last one, which he has said that that there has been overlapping of jurisdiction in the sense that Arunachal Pradesh Eviction of Unauthorized Occupant Act has been involved. There is no finding. There is nothing in the decree which shows that such a jurisdiction has been involved. It is the authority of the civil court to give a decree of ejectment, which has been done. So I don't know where this has come from. This is certainly not a question of substantial question of law. So in my humble submission, there is no substantial question of law which this honorable court may even issue notice. Lordship, I would also like to place reliance on one judgment, since he has mentioned about the plot of land, about the boundaries and all. The Honorable Supreme Court has said in this case that even if the boundaries of a land, if it is wrongly decided, then also maybe it is a mere wrong finding of fact. It cannot be a substantial question of law. This Lordship, I am relying para 8 to 12. Para 8 to 12. Also, Lordship, another one. I'll just read out, Lordship. This is 1999, 3 SCC 722. This is is in this.
No, that's will not frame, but then the issue of they have relied on the allotment.
Yes,
Allotment,
yes.
land allotment passbook.
Who, Lordship?
The first appellate court.
Yes. First appellate court has also taken note of the fact
Yes.
that after the land was transferred to the plaintiff, that is me, because the area was 450 square meters. Out of that, 374 was transferred to me in 2006 from Yamasoki. Yamasoki is the ex-wife of the appellant herein. Her allotment was in her name. She transferred 374 square meters to me in 2006. In 2010, she transferred the rest of the land, that is 74 square meters, in the name of the appellant. In between, there was no complaint at all against Yamasoki. The Honorable First Appellate Court took note of that also. Because the issue is not whether, because he has said that the land was in his possession, that he was occupying the land. There is no finding of fact from the trial court as well as the First Appellate Court that he was in occupation of the land since long time back. Even if Yamasoki was his ex-wife, she was the one who had the allotment. There is no evidence, there is no fact that he was at any point of time given the land and from there Yamasoki took the land. There is no such finding. So, basing on that, learned First Appellate Court has held that there is no cloud over the title of the plaintiff. So, therefore, she could ask for injunction even without seeking for title. Title she already has from the government.
Then, what is the next?
The next ground also.
What is the next judgment you are like?
Oh, sorry. Since your lordship. 1999. Hmm. 1999, Lordship. Volume 3, 722.
Yes, read it.
Yes, I'll just read it. 5 and 6. It is not within the domain of the High Court to investigate the grounds on which findings are arrived at by the last court of fact, being the First Appellate Court. It is true that the lower appellate court should not ordinarily reject witnesses accepted by the trial court in respect of credibility, but even where it has rejected the witnesses accepted by the trial court, the same is no ground for interference in the second appeal when it is found that the appellate court has given satisfactory reasons for doing so. In a case where from a given set of circumstances, two inferences are possible, one drawn by the lower appellate court is binding on the High Court in the second appeal. Adopting any other approach is not permissible. The High Court cannot substitute its opinion for the opinion of the First Appellate Court unless it is found that the conclusions drawn by the lower appellate court was erroneously being contrary to the mandatory provisions of law applicable or its settled position on the basis of pronouncement made by the apex court or was based on inadmissible evidence or arrived at without evidence. Para 6, if the question of law, term a substantial question, stands already decided by a larger bench of the High Court concerned or by a privy council or by a federal court or by the Supreme Court, its merely wrong application on the facts of the case would not be termed to be a substantial question of law. Where a point of law has not been pleaded or is found to be arising between the parties in the absence of any factual format, a litigant should not be allowed to raise that question as a substantial question of law in second appeal. The mere appreciation of facts, the documentary evidence, or the meaning of entries and the contents in a document cannot be held to be raising substantial questions of law. So in my humble submission, this is not a case for interference because it does not fulfill the test of substantial question of law.
Sure.
Yes, my lord. But in the event your lordship is not satisfied, then I have suggested my own
I'll
question of law.
let them know. One from him, one from.
Yes, I have proposed only one.
Yes. Two questions according to this code.
Yes.
One is whether the land allotment passbook gives a right of absolute title.
No.
That will consider. That will consider because once it is absolute, if one is gives absolute title to a person or the allottee, other questions.
Here in the case. Allotment.
Heard Mr. M. Pratesh, learned senior counsel, assisted by Mr. T. The learned counsel for the appellant. While promulgating question, while admitting it,
Yes.
and also heard MS N. Rangan, learned counsel for the appellant. That's the respondents. Having heard the learned counsel for the parties following substantial questions of law for consideration in this appeal. Number one, as to whether allotment of government land by issuing a passbook confers absolute title to a allottee. In other words, whether it creates or extinguishes title in favor of the allottee. Number two. Rather, if it's a settled position, it's a mere interpretation or of the first appellate court. If it is settled question of law,
Yes.
it cannot be a substantial question of law at all.
That's what.
That's why I'm saying we'll just see that and this your one of the second is as to whether the
Yeah. Para 24.
whether the whether a claim can be laid substantively that there is no pleading of recovery of possession and consequential relief. When the appellant public defendant knew the case to be that of recovery of possession and consequential relief. That's all.
Obliged.
Because other questions.
I have placed one document, one judgment.
Yes.
Here, this is the judgment
Hmm.
of 2007. Sorry. Para 24.
Yes.
The High Court should be satisfied that the case involves a substantial question.
That's why I'm satisfied and why we have promulgated two questions.
Yes.
Admit the appeal.
A question of law having a material bearing on the decision of the
Admit the
case.
appeal.
That is a question answer to which affect the right
Since
of the party.
MS
To the
Endagan appears for the
Respondent.
respondent, no formal notice need be issued. In the meantime, status quo.
Yeah.
In the interim, status quo adjourned today shall be maintained by the parties. That's all. Why unnecessary? We'll hear you. That Mr. Wait a minute, some more questions. Yeah. No, as per this judgment, the violation of settled position law itself is a substantial question of law, which we have placed. That's why we have problem.
CD.
CD receipt.
140 close to 140 BNS close to 353. My lord, I have filed a bail application under section 483 of BNS for release of the accused person on bail. Your Honor,
Earlier, it was registered for abduction. Then later on, this abducted person was found dead. And after, yes, exhumation, dead body was recovered. And now, 103 subsection 1, that is in earlier act, it was 302, was added. Slash 34. 34 means in DNS 3 subsection 5. Now it is additional section is earlier it was 140 subsection 3, that is for abduction, BNS. And 103 subsection 1, that is for murder. And 238 subsection 2 is for counseling and screening the offenders. Section 3 subsection 5 is common intention. Yes. That section is 103 subsection 1, that is for murder. Yes. It is in page 20. Yes, and
no, in actual
in CD it is in CD it is CD entry dated.
No, I have filed the bail application before the JMFC, Learner JMFC Daporijo. Honorable JMFC has been rejected the bail, and that time, Honorable JMFC was mentioned 103, and again
I filed before Session Court Pasigat, and that time 103 is not mentioned here. Only 140 close to, yes. As per order, Your Honor. As per the CD, when Pasigat Honorable Court, Pasigat Session Judge was called a CD, and that times I think 103 is not restricted, so that's he is mentioned in or as order. He reflected the 104. Yes.
Yes, person was taken from Demaji to Daporija. And now it's pending before Daporija case. Yes.
Fact of the case is that one Srimati Sri Sonomonali Nath was the zero FR was filed before Lekavali Petrol Post Demaji Assam on 23 August 2024. Allegation is that the one Sanjay Nath, who is brought the son of the complainant, Your Honor. And on 1 September 2024, Daporija police has received the zero FR from the Lekavali, and Daporija police has been registered a case.
Abducted person was killed at Daporija near CP village, river bank of Subansiri River.
Who is this accused?
Accused Yachak Rai. Yachak Rai.
What is your role?
CD entry dated 0209-2024. CD entry 09-2024. I have put the paper plate over the piece.
This one?
Yes.
Yes. 09?
0209-2024. Entry 4. Entry 4. Suspect Sanu Deepak Tamang was arrested. Then he confessed and his involvement and disclosed the name of sister-in-law that is now applicant, Mrs. Srimati Yachik Rai Tamang.
Yachik Rai Tamang.
Entry 4, 5, and 6.
So, what do you say? When she was arrested?
She was
on 09.
Yes.
How this 103 was added?
It was thereafter there was a disclosure of one person and another. Altogether, there are 9 accused in this case.
All of them have been arrested.
Yes,
All
have been arrested.
All of them.
Yes.
9 accused persons.
Yes.
Is
And
it?
yes. And investigation is not completed because PM report, postmortem report is awaited. Body was exhumed in presence of magistrate. And section that here, section 3, subsection 5 of BNS, that is earlier section, corresponding section 34, common intention is there. Severally, individually and severally liable for 302 or 103, subsection 1.
My lord, it is the presumed that women can be abduction or kidnapping to the men. It cannot be possible. It is the presumption. It is the presumption, Your Honor. Presume that women cannot power them to the men. Women cannot be.
There are nine persons involved. You are also involved.
My lord, my submission is that.
Not Mr.
My submission is that Elijah person is having a feeding baby, Your Honor.
You could have taught before that.
Even
Committing the offense.
No,
Evidence that you have all are involved.
even though I didn't know,
And you have confessed.
know the matter.
You have admitted.
No. I'm not admitted. I
It's
didn't
here.
not.
It's here. When you were called in the police, you have admitted and you have named some other accused also, and they have also been arrested. Let us see. You wait for some time. Let the investigation be fairly completed.
My lord, investigation has been already completed. Only postmortem report is required.
Is it?
Postmortem report
Yes,
is required.
it's almost completed. Postmortem report is still awaited.
So we'll release her.
Postmortem report is not required, my lord.
I will not comment on that point. I will leave it to this court to pass.
It's a 103.
Yes, 103 murder.
It is
Serious
a
offense.
involvement of you,
Section-
abduction and murder.
Yes. Section 3, subsection 5, that is common intention. Equally and severely liable.
That's what I'm saying. If you are
Yes.
saying that the investigation is completed,
No,
and
not completed. It is pending for
You said almost completed. If you almost completed, we'll release her.
almost means all the accused suspected were arrested and they all confessed before the IO investigative agency.
What, Mr.
Nyogen.
T.
Nyogen.
Nyogen, let me
Yes.
counsel for the applicant, and also have Mr. Jita, the learned counsel, learned additional PP for the state. Next paragraph. This is an application under section 483 of BNSS 2023.
Yes, 483.
It's not BNSS Act, it's BNSS 2023. For applying for grant of bail to the accused person, namely Srimati Yachak Rai, in connection with the Daporizio PS case number 60 of 2024 under section 140 within bracket close 103. What is that? 103 also
Yes, 103 subsection 1,
within bracket 1 bracket close oblique
238,
3 238 also.
238 subsection 1, 238.
What does it mean?
It's counseling and this, yes, counseling of evidence
Under BNS.
and yes, under BNS.
238.
Yes, 238 subsection 1.
238 in bracket 1.
No, not 1, only 238. Only 238.
238/3 within bracket 5 oblique bracket close of BNS 2023. When you were arrested, 2nd of September,
Yes, second.
who was arrested on 02/09/2024. Next panel. An FIR was lodged before the officer in charge, before the in charge Likabali Petrol Post, Demaji, Assam, on 29/08/2024 by one Sri Sonamoni Nath of village Alikas, Likabali Police Station, Silapata, Demaji, Assam. To the effect that on 23/08/2024, Sri Arun Chetri, a resident of Madhuri Puthar, Rai Basti, page 15, Rai Basti, son of Dilip Chetri, took his son Sri Sanjay Nath to Geling, Arunachal Pradesh on his truck bearing registration number AS018 C4741. Please stop. Near a group of 4 to 5 unknown boys and girls at near Dapurijo Bridge in a Bolero car forcefully kidnapped his son. No information since last 1 week, no information could be gathered about the whereabouts of his son. And despite several reports, the whereabouts of his son Sanjay Nath could be found. This was forwarded to Dapurja PS. Where it is? Where do we get it?
There is no pagination. That's index is there.
Next paragraph. The written effort, the above written effort was registered as 0 FIR at the police, Silapur police station. what I said zero FR. The said FR was registered as zero FR at police station Silaputa and forwarded to the Daporizio PS, which was received on 01/09/2024, and the case being DRG /PS /C number 60 of 2024 under section 140 within bracket 3/3 within bracket 5, comma BNS 23. Registered being dear so and so registered before the Daporizio police station. This stuff. Next paragraph. During the investigation, it is founded that one Sri Tabu Doni, resident of Daporizio, Pakam colony, had sent a group of kidnappers to kidnap complainant, kidnap the son of the informant. As per the audio recording. Mr. The investigating authority has arrested one Sri Sanu alias Deepak Tama, and on interrogation, on examination, they said accused has admitted to his involvement in the abduction of the deceased and disclosed the involvement of some other accused. And the involvement of his sister-in-law, namely Srimati Yachakrai Tamang, within bracket, the accused hearing, bracket close. On disclosure, the accused was called in the police station. Was directed to appear in a police station for investigation. Accordingly, the accused, Srimati Yachakrai Tama, appeared before the police, and on interrogation and examination, she stated to have admitted of committing the offense of abduction and further disclosed the name of one more accused. Namely Sri Tarsis Bag, BHAG. This stuff. Tarsis Bag was also arrested. How many accused?
9 altogether,
Nine.
9. Same day,
Next
when
paragraph.
this applicant was arrested, the body was recovered, exhumed. It is on next page.
Recovered from where?
From riverbank of Subansiri, near Silly Blaze.
Altogether, it is seen that altogether there are 9 accused have been arrested. List of. On next day or same day?
On same day. It is in entry 12 and entry 13 of
13.
the TD entry 0209/2024. Next page where I have pasted next page of the entry 12 and 13.
Where it says that it was body was recovered from where? Bodies were recovered from where?
Near CP Blaze, Subansiri Bank, River Subansiri Bank, Daporijo. Entry 12 and 13.
Of 0209.
Yes, next page where I have pasted the
Next page.
Yes, entry 12 and 13.
Now sell to examination of this is body in connection. It is to the what does it say? Accused Ramsri and PS ready protein listed approval the request of exhumation of disease body in connection. From where you have recovered the body?
It's there in entry 12 and 13. May I read?
Just mark it.
Yes. That yellow paper. Entry 16.
16.
Entry 16.
16.
Yes, yes, that yellow paper plate I have just pasted.
This one?
Yes.
Next page. It is. Notice that the dead body, the body of the late Sanjay Nath was recovered from the place of occurrence located at 7 kilometers towards northwest police station Dafuja near CP village. And bank of Subansiri River. The police, after in compliance of all the procedure, has exhumed the body of the deceased late Sanjay Nath. Thereafter, section 103 within bracket 1 bracket close oblique 238 comma BNS 23 was added. On Mr. Swain's counsel for the applicants submits that you have not said that she's a baby-feeding mother. You just said you have a school-going children. Where have you said so?
I have minutes.
Where you have said that? Oh, breastfeeding baby, yes. Okay. Submits that the accused person is no way involved in the alleged offense, involved in the case apart from having a other school-going children, she has a breastfeeding baby. Which is just more than 1 year old. List of next period. Mr. Spencer, learned concept for the semester. Since the accused was arrested on 02/09/2024. Huh? Huh? She is in the jail home for 79 days as in today. List of the police has examined and recorded her statement, for which no further custodial interrogation is required. List of moreover, all the accused persons have been arrested. List of therefore, the accused person may be released on bail. Next bill. Mr. G. Tado, learned counsel for the learned additional PT by placing the case diary submits that all the accused persons, including the present accused, have confessed their involvement in abduction and murder of the victim, the murder of late Sanjay Nath. List of. Although the investigation is almost completed, however, considering the admission of involving in the commission of offense in the present case, which is serious in nature, the accused is not entitled to be released on bail. Next paragraph. Consider the submission of learned counsel for the parties and also peruse the case diary, skin copy case diary produced by the learned additional PP. Next paragraph. Having considered the record, it appears that the accused has admitted of her involvement in the commission of offense. List of however, as submitted with learned additional PP and on materials, submission with the custodial, the investigation of the case is almost completed. Therefore, in my considered view, a custodial introduction may not be required, as the accused was arrested 78 days back. List of that apart, all the accused persons have been arrested as on date, have been arrested. List of having considered above and considering that the accused person is having a breastfeeding child and a permanent resident of which place? Huh?
Nava place. Pio Lenkin, he is not sure.
Permanent resident. Are you really permanent resident? Permanent resident of Nava village, NAVA, under Limaking Circle, police station, Nacho, district Upper Subansiri, Arunachal Pradesh. I deem it appropriate to allow the. I deem it appropriate to allow this application by granting. Allow this application by granting the bail to the accused person. Accordingly, the accused person, namely so and so, what is Yamarai? Yachakrai Tamang, be released on bail in connection with so and so, on furnishing a bail bond of rupees 10,000 with one local security, one security of like amount to the satisfaction of which district and sessions court will release. CGM.
Yes, CGM Dapurejo.
103. By
Yes,
whom?
yes, by satisfaction of the session court. Session court.
Learned Sessions Court. On the following conditions. What should be the condition?
Condition. As an on call for if further investigation required,
Then the
not to leave the station without the permission of
shall cooperate with the investigation. She shall appear before the investigating authority and the court as in when called for. The accused shall not leave the jurisdiction of
without the permission of OC concern. Yes.
Shall not leave the jurisdiction of officer in charge, the police station without written permission. And other witnesses, that person.
Oblige.
Oblige your.
They live in state.
Your lordship.
Yes.
Your Lordship, this is an application under 482. For
Why
causing
it been listed today?
It's for order.
Yes. So
Steps complete and respondent has, private respondent has filed their written statement.
okay. Heard Mr.
R. Raksap.
Raksablan, counsel for the service completed. Mr. Also heard Mr.
J. Sarolo.
No, before that. Heard Mr. So-and-so learned constable. Mr.
J. Sarolo. J.
For appears for respondent.
Private
Number-
respondent number 2.
Respondent number 2. Before that, also MS L. Hagel learned additional PP for estate and Mr. You are appearing for the first time.
Lordship.
Mr. So-and-so appears for respondent number 2. List for admission hearing after 2 weeks.
This is, your own. This was in order.
Yes.
This can be disposed of today since he has no objection, and meanwhile, this the case has been kept in abeyance at Alo.
So, any prejudice to you?
Yes, I have taken BRS, voluntary retirements, and now
Is it causing prejudice to you? Staying the proceedings, so we'll vacate it.
No, that.
At least after 2 weeks, yeah.
Yes.
Since Mr. R. Raksab, counsel for the petitioner, submits that staying the further proceedings of the, what is this? GR case number
Yes, year case number.
is causing prejudice to the petitioner. The interim order be vacated. Accordingly, this interim order passed earlier shall stand
No.
vacated. So,
Lordship, here interim was never granted, Lordship. It was wrongly reflected.
yes,
Interim order never granted, Lordship.
okay. So
Actually,
delete all that.
Your Honor, the problem is that it has been kept abeyance. If the
Well-
case proceeds there, it is in it. We have already filed an joint petition on that.
So we'll direct them to proceed.
No,
She said there's no interim order. Staying the keeping abeyance of the proceedings.
that court themselves has kept it abeyance.
So we'll direct them to proceed with the proceedings. All right,
No, Your Honor, this may be taken up.
then
They themselves has kept in abeyance. I
what
think
is the
the
offense?
offense is now 324. Initially there was 3 offenses. He was deployed as a guard commander at the
Okay.
residence of CGM court, London CGM court, Alo.
Yes,
So he had a minor, since the minor child of the Honorable Judge Respondent number 2 was trying to go outside of the gate. He had stopped him, and then that child entered inside the house of the Respondent number 2 and started crying. Then his wife came out, and then both they had some altercation. Thereafter, the Respondent number 2, who is the judge, he had pushed out the guard commander from his house, and then he lodged an FIR. FIR is in page number, he lost an FIR, it's in page number 19, Your Honor. Then thereafter he was arrested, and then thereafter he arrested, then he was granted bail, and CC was conducted, 2 charges were dropped. Then during 313, in the court of Lanet, CGM, Alo, Tadu Tamang, he is taking up the case under 303. His written statement.
So-
my written statement.
What do you say? You have no objection?
Lordship, since, yes, I rendering my no objection pertaining to this matter, Lordship.
Page 37, Your Lordship. We have tried to file 3 under CRPC 320 for compounding of the case, that is 324. But since the Lanet CGM has kept it evidence stating that the informant child is like his own child, so he cannot deliver. Still, he is transferred out from that court. He cannot pronounce the judgment. So, since then, it is kept in abeyance without any further proceeding.
Any settlement out there?
Yes, page number 37, Your Honor. This-
With respondent number 2?
Yes, respondent number 2. We both have this page number 38 also. There is,
That case,
yes,
heard so and so, disposed. Hello?
yes. Oblige, Your Honor.
In item 13, it may be
Yes.
reflected that CD is on.
Huh?
Maybe in item 13, it may be reflected that CD
Is it not a scanned copy?
What we have to send it back.
Okay. In item 13? Send back the case there. Copy of the case there. Scanned copy is not required. I think you send it back.
Lordship, here, Lordship, step upon respondent number 2 is still available.
Award service record in respect of respondent number 2. List after 3 weeks. 2 weeks or
Relax.
3 weeks?
3 weeks.
3 weeks.
Like,
Interim may be continued.
May I please, your
Interim
lordship?
be continued.
May I please, your
Interim-
lordship?
Yes.
Lordship, on the last occasion, IA was supposed to be heard.
Yes.
However, yes, I have gone through the interlocutory application that I have
Yes.
filed before this honorable court. That there are certain provisions that has inadvertently not followed, Lordship. So may I pray that I may be allowed to withdraw the interlocutory application.
Will it be permissible?
Lordship, order,
Is it permissible?
Lordship, 23, order 23. CPC.
Let us see. I don't know how we are proceeding in. Be careful.
Lord,
Mr.
Lordship,
Tatak.
despite my
Order
23, Lordship,
23.
yes.
You file an application.
Uh,
You file an application.
Lordship. And
I'm heard, Mr. A. Tatak, I'm counsel for the petitioner oblique applicant. The IA 207.
Lordship.
He has filed an IA. No, in in the IA, huh? IA 207, huh? It's not in election petition. Mr. Etatak, learned counsel for the applicant, submits that while filing the IA 2007, IA number 207, while filing the present IA, he has inadvertently you should submits that inadvertently he has filed the present IA, being IA number IAC number 207 of 2024 as certain provisions of law has not been complied with.
Lordship.
Therefore, he prays for some time to file and to take steps for filing appropriate application for withdrawal of the same.
Lordship.
Right?
Lordship.
Is that it?
Lordship.
He prays for, in that case, we'll say he prays for some time to take appropriate steps in this regard.
Lordship. Lordship.
Mr. Will it be all right?
Lordship.
You have to file an application for withdrawal.
Lordship.
Right?
Lordship.
Mr.
And from respondent number
First,
3.
who is the number one?
I am 41.
Mr. M. Logi, counsel for the opposite party. Oblique. Respondent number 1.
Your Lordship, I am for respondent number 3.
Who is for 2? Miss M.S. so-and-so, so-and-so, for respondent number 2 are present. List the matter. What, then when?
Lordship, can it be on 26?
It's not possible.
Along with documentation, Lordship.
List the matter.
Lordship, as as on the last occasion, Lordship was at Guwahati, so at that point of time we could not do the
list it
documentation.
on 28 Thursday. 28.
29, Lordship.
29 Friday. It's not possible. 29 Friday.
Yes.
28.
Lordship. Deeply honored.
Unlisted. This is what?
May I please, Lordship? It's in this instant writ petition, Lordship, I have assailed the impugn transfer posting order dated 29/10/2024, Lordship. Lordship, in this case, basically, the private respondent who have been transferred and posted in place of the petitioner is a in charge, Lordship. The respondent petitioner is executive engineer, is a regular executive engineer. And
which for KBH?
Your Honor, I am for the respondent KBH. Your Honor, I just received a copy of petition.
We'll take it up tomorrow.
Lordship, I have certain health issues.
On 26. Can it be here on 26?
No, we'll hear you tomorrow.
Lordship, in fact, this case is a covered case, Lordship. Lordship is aware, even on the last occasion.
Not covered, what covered case?
Yeah, similarly situated case in writ petition 444, Lordship. Lordship was pleased to grant interim, Lordship, on the ground that there cannot be a inter se transfer between the officer who are not similarly placed with, Lordship.
No, see, he said he had just received the copy.
Yes,
Lordship,
We'll hear
since
tomorrow.
they have already got the instruction, Lordship, that with regards to, in fact, they have filed the caveat, Lordship.
That's
So
why
they
we'll hear tomorrow. This tomorrow. All right. List the matter. on 2022. All right.
Lordship. Deeply obliged.
Yes. Mala, in this rate petition, Mala, we are challenging the land position certificate, Mala.
What is the urgency? Why this has been listed?
Mala, what happened is that the land position was illegally taken by the respondent, and that's in the same stage of land. The survey and survey will be done on 26/11/2024. So if we are praying for the stay of this land position certificate, which was issued by Deputy Commissioner without following the guidelines of the state government, and even
LPC issued to whom?
If LPC issued the respondent mailer, we have made a respondent mailer. Respondent mailer, respondent number mailer.
Where is this
4.
LPC?
4.
Where is the LPC?
Yeah, LPC is mailer in page 35.
Have you approached the Deputy Commissioner?
We have approached the Deputy Commissioner. We have filed 2 representation, and the matter is still pending before Deputy Commissioner. And meantime, Deputy Commissioner has issued a circular for the survey of that particular.
What is no objection certificate for land position certificate? By whom?
The no, it has to
by
be
the
by the Gamburas.
DFO.
DFO, Gamburas of the concerned village. Well, you'll also see the guideline is page 46 and page 47. Now, as per the guidelines, NOC has to be issued the concerned Gambura, Panchayat leader, and then DFO. So in this case, LPC was issued only on the basis of the certificate NOC issued by DFO. There is another.
Mr. Esmo, counsel for the petitioner. Petitioners?
Yes, my lord. Petitioners, my lord.
Will issue notice, that's all, nothing else.
My lord,
we'll see. Private,
Other-
let the
oth-
private respondent
Otherwise,
come.
my lord, the president will be called because the respondent has got a certificate, position certificate, and the survey, if it is done, then the.
Then in that case, LPC will say LPC will stay the LPC.
Yes, my lord.
But then will not stay
Yes,
the
yes.
survey.
Yeah, that
will allow it to continue with the survey because that will because of stay of the LPC, the things will not change.
Yes, your lordship.
The geographical and all these things will remain the same. So you continue the survey.
All right, that's all.
What survey? What sort of survey?
It's for land comparison, for a land assessment, my lord.
There is the problem.
Circular is, my lord, it's in page 63.
By filing this writ petition, the petitioner has put to challenge the land position certificate bearing number 643.
Yes, my lord, the page.
Dated 17/02/2024, issued by the Deputy Commissioner Lord
Dibangmuli.
Roy.
Dated 17/2/2020.
Yes, I've said so. 17/02/2020. Next para. Mr. Esmo, Learned Counsel for the Petitioner submits that the impugned LPC dated 17/02/2020 has been issued in violation of the guideline, prescribed guidelines issued by the Government of Arunachal Pradesh. Please stop. Who is the respondent?
Respondent is a private respondent, my lord.
You are no. You are petitioners.
Yes, we are petitioners, my lord.
You said petitioners, huh? And respondent, how many respondents?
Only one respondent, my lord.
Okay. Why you are saying you are claiming that land belongs to you?
Yes, my lord. We have also got compensation in the same land, my lord.
Huh?
In same area, that area belongs to us. It's ancestral land.
Mr. He submits that the land belongs to the land is the ancestral land of the petitioner, on which the respondent number 4, namely Sri Omana Mito, has no right.
Yes.
List of issue notice returnable by 4 weeks. MS Arbasar Learned State Council appear and enter appearance and accepted notice on behalf of respondent number 1, 2, 3.
2 and 3, Your Lordship.
Huh?
1 is
2 and 3.
standing
Non
counsel
appears
is there.
for respondent number 1. Mr. Since MS Arbasar Learned State Council appears for respondent number 2 and 3, no formal notice need be issued. Our extra copies will furnished to the learned court. Issued to the respondent number 2 and 3, huh, Mr. Next page. Extra copies, huh? Be furnished to the learned council, state council. Petitioners to take steps for service of notice upon respondent 1 and 4. Within within 2
Yes,
days.
1 and 4.
Registered post edition, huh? Next para. Considering that the LPC, the impugned LPC dated 17 to 2024. The 17 to 2020 issued by the DC Deputy Commissioner, Lower Dibang Valley District, Roy appears to be prima facie in violation of the guidelines issued by the state government, till the returnable date. The LPC bearing number 643 1706 dated 7/0/2020 shall not be given effect to this term. However, the respondent authorities may proceed with the survey of the land for construction of infrastructure. What is to be constructed?
This is for the road construction.
Survey is going on.
Survey is not yet started.
May proceed with the survey and any survey or any other actions that would be required for the purpose of construction of the road over the land. List after 4 weeks. Yes, what is this?
Lordship, this is a writ petition filed by the petitioner challenging the auction notice and its subsequent process. The nutshell of the case in brief is that the respondent number 3, who is the executive engineer PWD Pasigat Division, issued an impugned public auction notice, which is in page number 24 to 27. Type copy is at 26, Your Lordship. That the respondent number 3 had issued auction notice in connection to condemned bridges, more particularly MS Tabular Thrust Bridge over Sibokorang.
When is what issued?
Notice was issued on 5/11/2024. It is in page number 27, last line it is written. So after issuing notice, in the notice itself, it was given that the last date of quotation will be opened in the office chamber of Executive Engineer PWD Pasigat at 11:30 hours on 13/11/2024
by the board official and officers.
Yes.
As accordingly, the petitioner herein in person presented in the said auction process in the office chamber of executive respondent number 3. But surprisingly, Your Lordship, my tender bid was not allowed, and I was not allowed to participate in the said auction process without any valid reason, and the reason best known to the respondent authority. I was arbitrarily and fraudulently, I was not allowed to participate in the said tender
Sir, simply
process.
saying will not do. So show us why you have been
Lordship,
allowed to participate.
selection and non-selection and eligibility and non-eligibility of my bid will be only taken care after I was allowed to participate.
So how do you know?
This also the requisite
Yes,
terms
what
and
is to be done?
Lordship terms.
Better we fix on Tuesday. Monday is holiday, so
We'll ask them to take instruction. It's already over.
It's already over.
So it is 21.
Lordship, till
We'll take
then
it up on Tuesday.
interim order stay.
What is the interim order? It was
Till then-
already taken place on 13.
13.
And you are not able to show how you have not been allowed to participate.
Your Lordship.
What is your eligibility?
Yes, yes.
We'll consider on.
I will
We'll ask
address
them to
this.
take instruction. We'll pass on that day. We'll consider the interim order on that day.
Lordship,
Because already auction has been conducted on 13, 11,
Yes, my
7
right.
days back.
Yes, Lordship, my right was violated.
So we'll
Uh,
consider that. Whether it has been violated or not, we'll consider.
Till then, Your Lordship.
No, it's not possible. It's wrong. Wrongly
Because,
or rightly, you have been rejected. It's been
because I was not
Al-
even allowed to
already-
participate, Your Lordship.
Sir, already the auction has already been conducted. We'll consider on that day.
Your Lordship, kindly 1 second.
What?
I'll show you that my my bid paper is annexer
It's
annexer
okay.
3.
I was not getting anything from your bid paper. Why you have been not allowed to participate? Why you have been rejected? You show us something. That's why we want to know.
Even my application
What
was
sort of stay we can give? What sort of stay we can provide? What interim order we can provide?
this Lordship, this proceeding may be till stay. It will be nothing will cause harm. Till then,
How can we stay the proceedings?
Because,
This is
I-
already
being an-
conducted on 13 on your own showing.
Lordship, I am
Already conducted. Auction is conducted already.
I have Lordship on the same day. I have even filed a representation, which is in page number
Sir, we'll
30.
consider on Tuesday. Don't worry. You come prepared along with better materials if you have also. Whatever you have annexed, I'm not. It's neither here nor there. We cannot make out anything from
because,
here.
because I was not allowed to participate.
That's the
That is
problem.
the problem.
Why you have not allowed to participate? We'll take instruction.
Yes.
If you have you have not been allowed to participate wrongly or illegally, we'll stay the
Till
proceeding.
then, Your Lordship, proceeding may be stayed.
What till
Otherwise,
then? What till
it
then?
will no purpose will be served, Your Lordship.
Heard, Mr.
Be come that, Lordship.
Learned counsel for the petitioner. By filing this writ petition, the petitioner agreed of not allowing him to participate in the auction process pursuant to the auction notice dated 5/11/2024. For quotation of public auction of MS Tubular Truss Bridge. It is tubular or tabular?
TUBU.
Tubular Truss Bridge over Sibo Krong River, issued by the Executive Engineer, Pasigat Division, APPWD, Arunachal Pradesh, has filed this petition on the ground that his bid he has not been allowed to participate on the date of auction on 13/11/2024 without any reason and arbitrarily by the state, by the respondent authorities. Mr. MS, Mr. Estapin, London, Senior Government Affairs, is directed to obtain instruction as to why, as to the reason, obtain instruction, list the matter on 26
Tuesday.
26/11/2024. And till such time, no finalization of the auction may be made.
If not already made.
If not all, no finalization till the next date, no auction, no no auction process be finalized, if not already finalized. If not already finalized, because it was already opened on 13, 1 week back.
Here the statement
Yes.
is the respondent 4 has been selected. It's all the
Lordship,
statement.
it is in
So, by
in
now-
my, it is from reliable source, it was
Then
informed
next
to me that the
that's
Lordship.
all. Till next date, no finalization of the auction process, if it is not already finalized. All right? Yes, next.
This is same matter,
Same.
similar matter, only the petitioner is different and the item is different.
Item is, which is that item is page.
Page 20.
Auction notice, same date.
Yes, notice same date, issued by same respondent.
Auction notice 5 same, but the item would be for quotation for public auction of Valley Bridge, page 27, huh? Valley Bridge at Ruksing Nala, so and so. Number 2, Valley Bridge at Penang Bay, Valley Bridge at Dobu River, so and so, huh? Page 27. Item is different, rest are same, huh?
Deeply obliged.